Morning. The time is now 10 a.m. Please call the case.
Good morning. Today is January 21st, 2020, and the time is now 10 a.m. Today we're hearing appeal number 2020-013 AP for Mark Gardner of the Atlanta Police Department. Mr. Gardner was dismissed for violation of Atlanta Police Department Work Rules 4.2.50, maltreatment or unnecessary force. Mr. Robert Hawkins will be chairing today's hearing.
Okay, as indicated, I am Robert Hawkins. I will be chairing today's hearing. I am joined by Mary Ann File and Pleeman Elamine. We are the hearing officers for the Civil Service Board. If you would, if the parties for the city and for the appellant would identify themselves, starting with the city.
Yes, good morning to all of our hearing officers and staff. We appreciate your taking the time with this matter this morning. I am Allegra Lawrence Hardy here on behalf of the City of Atlanta. And I'm joined by Karima Lewis from the City Attorney's Office, as well as you will see a name on the screen that is listed as city exhibits. That is where we will be showing our exhibits today. And in that room are Lisa Haldar and Rod Gansky.
Okay. And for the appellant?
Good morning. My name is Lance LoRusso, and I represent the appellant, investigator Mark Gardner. There's a few folks you'll see on the screen from my office. Kayla Fulgham is my paralegal extraordinaire running our exhibits. Ken Davis is quarantining, but he is at home. And so he may appear on the screen. I believe, Ms. Harmon, he's trying to get in. And the appellant, Mark Gardner, investigator Mark Gardner, is on the screen as well.
Okay. Before proceeding, have the parties had any settlement discussions to try and resolve this issue?
We have, Mr. Hawkins.
We have, Mr. Chair. We have not been able to do so.
Okay, so we'll proceed. Let's go off the record for just a moment so I can outline for Mr. Gardner how we're going to proceed. There will be opening and closing statements by both parties, with the city going first. Witnesses will be called to testify. The panel may question the witness at any time during the testimony. If the appellant has anything to say, please say it through your counsel and not out loud. Please be reminded this is an administrative hearing, not a courtroom. The board is not bound by any rules of evidence. Most testimony and evidence will be admitted, including hearsay. If testimony is redundant and cumulative, the board may request that evidence and witnesses be limited. Now, I would like to ask that we all put your cell phones on silent and be cognizant of the fact that the hearing is being transcribed. These proceedings are subject to appeal, so it is important that we have a legible record. Please do not speak out of turn, but wait until you're prompted before speaking. Are there any questions?
None from us. Thank you, sir.
And we have no questions. Thank you.
If not, let's go back on the record. Are there any stipulated facts?
Mr. Chair, there are a group of stipulated facts. You should have received those yesterday. Ms. Lawrence Hardy's office and I believe, worked pretty diligently to put those together. They're rather extensive. They were provided to Ms. Harmon, I believe, just before or right around 2 p.m.
Okay.
You can send them again if that would be the
no,
board.
yes, excuse me. We do have them. Thank you very much. There are 12 stipulated facts. We do have all. Okay. Facts. Thank you.
There are also exhibits that are stipulated as well, sir. We tried to minimize bickering and arguing about exhibits, as lawyers are prone to do. So I think that we've stipulated to a great majority of them. And what we will do for your convenience is try at all opportunities to remind the panel that this exhibit is stipulated, so we can dispense with any questions about admitting it.
Okay, thank you very much.
We did that in an effort to get the time down, as you have already reminded us is very important. So we hope that that's helpful.
No, this is very helpful, and I'll be in the mix.
Thank you.
Okay, I think the witness list has been provided. We did receive the notice of proposed adverse action and the notice a final adverse action. So we are ready to begin. City, you are welcome to make your opening statement.
Thank you, and good morning, Board Member Fayal. Am I pronouncing that correctly? It's
File, just like fingernail file.
I will never do it wrong again. I noted before that I heard it about 8 different ways in our last hearing, so thank you for clarifying that. With a name like Allegra, I try to be careful. Very good to see you, Ms. File and Mr. Elamine again, and for Mr. Hawkins' benefit, I will note that we were together 2 weeks ago for a hearing for former APD officer Ivy Streeter. We have noted that there are some redundancies in between. Obviously, this is an independent case, but attempted to streamline the presentation on evidence to really address the timing issues. Like Mr. Streeter, Mr. Gardner, the appellant today, was also dismissed from the Atlanta Police Department for unnecessary or unreasonable use of force during the Atlanta protests on March 30th of last year. He deployed his taser against a young, unarmed, nonviolent woman in violation of APD work rules. Former APD Chief Erica Shields, who is the decision maker in this case and today's only relevant witness, considered the best possible evidence of Mr. Gardner's conduct. She reviewed extensively footage from multiple officers' body-worn cameras and then directed his dismissal. We will, of course, show you some of that footage today. I know I may be repeating myself from 2 weeks ago, but I think it's important to make sure this case stands on its own, and that Mr. Gardner deserves that. So I just want to again take us all back for the moment to the time when Mr. Gardner was terminated. On May the 25th, 2020, 5 days before Mr. Gardner used unnecessary or unreasonable force, a Minneapolis policeman exercised his authority to carry out the murder of George Floyd, a Black man. If you'll remember, this is a murder that we all witnessed because we all saw it on television. His fellow officers looked on passively, though bystanders caught the entire event on video, which quickly went viral and was picked up by multiple news agencies, horrifying millions of Americans and igniting protests across the nation, including right here in our city. Some protesters turned violent and destructive, threatening conditions never before visited upon our city, as Chief Shields will tell you. People were angry. The situation was extraordinarily volatile, inflamed by intense media coverage of protester-police interactions. Against that backdrop, APD needed to be on its best behavior without deviation, let alone reckless deviation, from protocols or work rules. Properly trained officers like Mr. Gardner understood the de-escalation was warranted, required to quell significant and citywide unrest owing specifically to the flagrant police brutality that ended George Floyd's life. Appellant Gardner was an APD sworn officer. He had over 22 years of experience, and he also held a highly coveted assignment, the fugitive team. You'll hear from Chief Shields that only 2 months before his misconduct, which is now at issue, he refreshed his training on de-escalation and use of force. He knew that he was walking into a sensitive situation when he went to work as an APD officer on May 30th, 2020, only 5 days after the police murdered George Floyd. His de-escalation training was made for a situation exactly like the one facing our city. Yet on that day, rather than de-escalate, Appellant Gardner used unnecessary or unreasonable force. He deployed his taser against a young, unarmed, and non-violent woman, who we now know is Miss Tanaya Pilgrim. We will show you today some of the body cam footage. Miss Pilgrim was not one of the people throwing objects at the police. And in fact, she was not even taking part in protests. She was simply a passenger riding in a car in downtown Atlanta with her friend. She committed no offense, let alone one that called for the brutality that she experienced. The videos we will show you are clear and leave no room for error. You will see that Appellant Gardner rushed into the scene after numerous officers had already surrounded the students and their vehicle. And without ascertaining anything about the situation, he immediately deployed his taser against Ms. Pilgrim, who, as you will see, is clearly terrified and doesn't even have a real opportunity to get out of the vehicle she is in, as she's told to get out and stay in simultaneously. And especially because the world, again, observed this violence broadcasted on social media, Mr. Gardner's actions perpetrated a climate of fear and public distrust of the APD. As you will hear, the day immediately following Appellant's tasering of Miss Pilgrim, which was a Sunday, Chief Shields spent multiple hours reviewing videos of the incident. She watched it from numerous body cam angles, knowing that the city was a tinderbox. She knew she had to swiftly resolve the threat that Appellant Gardner's continued employment posed to the city. And she also knew that threat extended to the APD officers serving under her command. Knowing the video of Appellant's tasering of Miss Pilgrim would further inflame the city, she had to take fast, official, and decisive action, as city executives are often required to do. And indeed, Chief Shields had the courage that day to take quick, decisive action to avoid continued threats to the APD and to the city that she has served since 1995. She understood that APD officers were working under hazardous, stressful protest conditions. Protesters threw things at them. It was a hot evening. They had to wear uncomfortable riot control gear. The threat was very real, and officers legitimately feared for their safety. But considering the city in its entirety, which included Chief Shields' officers and the citizens those officers are sworn to protect, Chief Shields understood protesters feared for their safety too. Unlike citizens, unlike college students, APD officers, like Mr. Gardner, are all trained with protocols, including how to de-escalate a situation before using a taser against citizens to pull them from their vehicles, as Ms. Gardner did with Ms. Young. And importantly, under the Atlanta City Code, Chief Shields is the only person who can decide to terminate an officer. All other testimony you may hear about how other officers or outsiders felt about this incident is simply not relevant. Under the code, it is and was the chief's judgment and no one else's that matters. When this board sees shortly the evidence of Mr. Gardner's conduct, especially the body camera footage, we believe you will agree that Mr. Gardner used unreasonable or unnecessary force on May 30th, and that you will uphold his dismissal. To the extent the board has questions about the incident, we ask the board to respect the judgment of Chief Shields, as she considered all of the factors relating to the May 30th decision before making it. And she will, of course, be here today to explain her decision and thought process and to answer any of your questions. We ask this board to consider and acknowledge the Atlanta Police Chief's authority, particularly given the need for the chief to discipline officers to ensure protocols and work rules are followed, even in stressful situations, and in fact, especially in stressful situations. Turning to the procedural aspects of Mr. Gardner's termination, again, Chief Shields viewed multiple hours of footage. Nothing in the code requires that type of review, but she investigated thoroughly Mr. Gardner's conduct with her own personal and comprehensive review of the events from the best evidence that was available then or now. Mr. LoRusso will of course suggest termination in all cases requires nothing less than a standard investigation by the Office of Professional Service, otherwise known as OPS, and a written statement by the appellant. Yet nothing in the city code requires such an investigation or a statement by the appellant, and the Georgia Court of Appeals has been clear on this point. You will also hear from appellant's counsel that Atlanta City Code section 114.532 applied to this termination, but section 532 applies to suspensions. Appellant's counsel has not thus far spoken of Atlanta City Code section 114.526A. This is our exhibit 5, which specifically provides that when the employee's presence impairs the effectiveness of others, action shall be taken to immediately remove the employee from the work environment. The Georgia Court of Appeals, this is again the Hanrahan case, has interpreted this precise section of the city code to mean the APD chief may immediately dismiss an officer whose actions affect the public standing of the APD. As you will hear from Chief Shields this morning, Appellant Gardner's unnecessary and excessive tasering of Ms. Pilgrim on May 30th most certainly affected the APD's public standing. And once section 1114-530 is triggered, the Atlanta City Code 114.530 governing terminations in an emergency situation is what tells us how the city may immediately terminate an employee. It's not section 532 that is applicable, as you will hear today. Section 532, again, on its face, applies only to suspensions in emergency situations. And you'll see that just by looking at the city code. The relevant section, 530A, provides that in an emergency situation, the adverse action may become effective immediately following the employer's response, if any. So if the employee gets an opportunity to respond, and this response can be oral or written, there is no requirement to provide a written statement. Considering section 114-530, the city, at the direction of Chief Shields, prepared a notice of proposed adverse action. You'll see that as our City 01 exhibit. The city then delivered it to Appellant Gardner, and he signed his acknowledgement. The NPAA provided a time, 6 p.m. on May 31st, for an in-person response from Appellant Gardner. The chief was available and Mr. Gardner showed up, but as you will hear, Mr. Gardner elected not to provide a response at that time because he wanted to wait for his union representative. That was his choice to do so, but the code did not require the chief to wait for his union rep. It was Gardner who decided not to use his response time to tell his side of the story. And once Mr. Gardner was given that response opportunity, section 114.530 of the city code provided the adverse action became effective immediately. And indeed, Chief Shields handed him his final notice of adverse action. The emergency procedures in section 114.526 and 530 are sufficient to resolve this appeal. What you will hear from appellant's counsel respecting section 114.532 and with description of OPS and their investigations is a proverbial red herring. These code sections are completely irrelevant here, where the chief of police fully appreciated a significant emergent threat to Atlanta public safety and to the safety of her officers. Again, a red herring. Because the continued employment of Appellant Gardner would impair the effectiveness of the APD, both the code and Georgia case law allowed the chief to act as quickly as she did in terminating them. You also will hear from Appellant's counsel today about alleged due process concerns. But the record is clear that Mr. Gardner received notice and opportunity to respond. He showed up and is now receiving this 3-hour termination hearing before an objective board. We would submit that he has had full access to due process. I will close by reiterating that Appellant Gardner was subject to and aware of APD Work Rule 4.2.50, prohibiting him from the use of unnecessary or unreasonable force. He violated that rule when he deployed his taser unnecessarily at Ms. Pilgrim on the evening of May 30th, 2020. The world saw Appellant Gardner's choices that night, and justice was required. Accordingly, Chief Shields immediately and thoroughly reviewed hours of video of the incident the next day, on Sunday, May 31st, and considered all of these concerns against a backdrop of what was unfolding in the city she was sworn to protect at that time. She acted quickly and courageously, with bold leadership for a moment in a city that needed leadership. And she determined that Appellant's continued APD employment would risk officer and public safety. A police chief's judgment is what matters in a case like this. That is what the code tells us. And Chief Shields exercised her judgment in accordance with the Atlanta City Code procedures, specifically sections 114-526 and 114-530. And just as in the Hammerhand case, where the Court of Appeals affirmed this board's decision to uphold an officer's immediate dismissal, Chief Shields was authorized by statute to immediately dismiss Mr. Gardner. We ask that Mr. Gardner's dismissal likewise be affirmed here and ask that Appellant's appeal be dismissed. Thank you.
Mr. LoRusso, your opening statement, please.
Good morning. My name is Lance LoRusso, and I have the honor of representing the man you see on your screen, Investigator Mark Gardner. Investigator Mark Gardner has approximately 23 years of experience with the City of Atlanta Police Department. He is a college-educated, extremely well-trained law enforcement officer with over 2,400 hours of training, including extensive training on the use of force, use of deadly force, use of non-deadly force, procedures regarding the apprehension of fugitives, riot patrols, all of the types of things that you are going to see at play here. And it's important to remember, he not only received this training from the City of Atlanta, he was a task force officer with the FBI for 10 years. That means that during that time period, he received his use of force training, his de-escalation training from the City of Atlanta and from the Federal Bureau of Investigation. This is an extremely well-trained man who gave hours and years to the city. In 20 years of his evaluations that we've been able to gather, 15 of those years he was rated highly effective, the second highest rating. And in the other 5 years we found he was rated outstanding. That sums up the past 20 years of his experience. He is a faithful servant to the city. His daughter just finished college and is starting PA school. And he was terminated without an investigation in violation of nearly every applicable policy and ordinance. His due process rights guaranteed by the city ordinances and the United States Constitution and the state constitution of Georgia were violated. Sections 114.530, 114.532, 114.527, and others, a half dozen policies you're going to hear, He went to work because the city asked him to. One of those days he worked a 21-hour shift. And now he hasn't had a paycheck since June 1st, 2020, because as you will hear, Chief Shields was just too busy to do an investigation. Policies and procedures of the city of Atlanta are not to be ignored. Not only are they not to be ignored, they are what the city officers live by. They're what the city officers live and die by. They guide them every day. 4 of those policies you will hear require, they use the word shall. They require the Office of Professional Standards to interview officers and do a full investigation prior to discipline. You will hear those statements. You will hear that one of those policies, the conducted energy weapon, for those of you who are not familiar, conducted energy weapon is a taser. Taser is a brand. The conducted energy weapon specifically says that if there's an allegation of misconduct or excessive force involving a taser, you must do an OPS investigation. This is the second time that the city of Atlanta has refused to stipulate that that policy is relevant to these proceedings. You are going to hear that Chief Shields said multiple times that she did not have time to extend due process. You're also going to hear that the policies and procedures of the city of Atlanta are bound by a case called Graham versus Connor that talks about a reasonable officer standard, officers working in highly tense, uncertain, and rapidly evolving circumstances. And that governs how we evaluate officers' performance. You're also going to hear that the officers that surrounded that car, as Ms. Allegra Lawrence Hardy stated, combined to have 120 years of law enforcement experience. They knew what they were doing. They knew what the laws were. They knew what the ordinances were. They knew what the policies were, and they acted appropriately. You are going to hear very clearly that contrary to what you've been told, and I wrote it down, that Chief Shields considered the best possible evidence, except for one really big thing. Investigator Gardner, why did you tase Tanaya Pilgrim? Nobody ever asked that question of a 23-year veteran who's trained by the city of Atlanta and the FBI, worked for 10 years as a federal task force officer, and worked on one of the most highly coveted positions, the fugitive task force in the city of Atlanta. Well, you're going to get a chance to hear the answer to that today, because apparently nobody saw fit to answer it, to ask that question before today. We're going to ask you to reinstate him, that his force was reasonable. He did not violate the city's policies. The city failed to do a proper investigation. He did not violate Work Rule 4.2. And we're going to ask you to reinstate him with all of his benefits, back pay, and do what's right by this officer and afford him the due process that he expected he would get when he put that uniform on and waded into the city of Atlanta into what the mayor described as chaos. And they weren't just chaos with people throwing things. He put that uniform on day after day while people were throwing incendiary bombs at that uniform. And he is hoping that you will listen to the evidence and extend him the courtesies of those policies that he lived and died by. Thank you.
Thank you. City, you may call your first witness.
Thank you. The city calls Chief Erica Shields, former chief of the Atlanta Police Department. And there she is. Good morning, Chief Shields.
Good morning. Can you hear me okay?
We can.
We
Thank you.
can. Thank you. Chief Shields, good morning. Do you have any objection to taking an oath?
Oh, not at all. Thank you.
Please raise your right hand. Do you swear or affirm to tell the truth?
I do.
Would you please state your name, your job title, and years of service with the city?
My name is Erica Shields. At the time of the incident, I was chief of police of the Atlanta Police Department, and I had been there 25 years.
Okay, thank you.
Thank you.
Thank you, Chief Shields, and good morning. just to make sure we were clear, you were chief of the Atlanta Police Department on May 30th and May 31st, 2020, correct?
Correct.
You are no longer chief of police, is that correct?
That is correct.
So I want to take you back to May of 2020 and talk to you about the Atlanta City Code that relates to the hiring and firing authority you had as chief of police. We're going to start by showing you an exhibit. This document has been marked as City 04 and stipulated into evidence, I note for the board. It is Atlanta City Code Section 98-28, titled Hiring and Firing Authority, Qualifications of the Chief. Do you see that there on your screen?
I do, yes, thank you.
And I want to specifically draw your attention to subsection A that says that the police chief is the hiring and firing authority for the Department of Police, subject to applicable ordinances, rules, and regulations. Are you familiar with this
Yes.
section of the code?
Yes,
And as chief, were you the one with authority to make firing decisions for the Atlanta Police Department?
I was, yes.
And in fact, you had the responsibility to do so, correct?
I had an obligation to do so, yes.
I now want to talk about the APD work rules, and we're going to show you what's been marked as City 03, which is APD SOP 2010, Atlanta Police Department work rules effective January 18th, 2019. I note for the board that this document also has been stipulated into evidence. Starting on the first page of this exhibit, can you tell me the effective date of these rules?
So it was effective January 18, 2019.
And were these work rules in effect on May 30th, 2020?
Correct, they were, yes.
We are going to move forward now to page 12 and show you on the screen Rule 4.2.5.0 regarding maltreatment or unnecessary force. Are you familiar with this work rule, 4.2.5.0?
I am, yes.
And are officers of the APD subject to this rule regarding maltreatment or unnecessary force?
They are.
And can APD officers be terminated for a violation of this rule?
They can.
Would you list for us, please, the types of considerations that you ponder over when you must make a determination as to whether officers have used excessive or unreasonable force in violation of this rule?
For me, I always looked at the totality of the incident. Why was the officer engaging in force? What was the charge? Was the officer alone? Were they fighting for their life in a house on a domestic in the middle of nowhere? Did they have backup readily available to them? Were there alternatives other than the particular levels of force they adopted? So it really is looking at the totality of the incident and seeing, was this necessary for what the officer was presented with?
Let's move on to talk about the appellant, Mr. Gardner. And at the time of his termination, he was an investigator with the APD, correct?
Yes,
And he also was a member of the fugitive team. Is that correct?
yes.
And what's the fugitive team?
So the fugitive team is directly responsible for serving arrest warrants on those individuals who are deemed to be of a higher threat. Or there's an urgency to getting someone off the street. So the detectives will pull together, do the investigation on someone, swear out the search warrant, and hand it over to the fugitive team. Their expertise is essentially tracking people down, finding people, so that the warrant can be served on them.
And this is a highly coveted team, is that correct?
Yes, people have always wanted to be on that team, and that is highly coveted.
And it has your more experienced officers, is that correct?
Correct, yes.
You can't be a new officer and get a place on the fugitive team.
No, you would not be considered for that.
On the evening of May 30th, 2020, what were your expectations of Mr. Gardner in his role as an investigator on the fugitive team?
My expectation would be that based on his experience, his time in service, and the fact that he, is active in the street on a regular basis, he hasn't been sitting idle on a desk for 20 years, that he would use the appropriate level of force necessary to make an arrest if one had to be made.
And as an APD officer, Mr. Gardner would have received training conducted through the Peace Officer Standards and Training Council. Is that correct?
Yes.
I'm going to show you what has been marked as City Exhibit 07, which is Mr. Gardner's training record. And for the board, I note that it has been stipulated into evidence. Looking at the first page, would you please tell us the 3 most recent trainings that Mr. Gardner completed and the dates of those trainings?
So on March 28th, 2020, he had cultural awareness, use of force, and de-escalation options for gaining compliance, 3 separate courses.
And Chief, I know that you were not present for the opening statements. Mr. LoRusso told us that Mr. Gardner had had over 2,400 hours of training over the course of his career. Does that sound typical to you for someone who had been with APD as long as he has?
Yes. I mean, I'd have to go back and look at my exact, but you accrue a bulk of your training hours as a recruit. But yes, that does sound reasonable.
Okay. And so let's focus on these last 3 because they seem extraordinarily relevant for what occurred on May 30th. Let's discuss the content of post-training on de-escalation options for gaining compliance. Would you expect such a training to include being level-headed and slowing the situation down?
Yes, so policing has really, in the last probably 8 years or so, really gone the inverse. For a period of time, all we did was train officers on, as the situation escalated, how do you respond? And with more force. And then what you really have seen in the last 8-10 years is an emphasis on, okay, wait, how do you back out of this? How do you not cause a situation to flare up further? How do you de-escalate it, bring things to a lower level, and step back away from what you're presented with? So de-escalation has included many things. Much of it is communication. Much of it is the training of a thought process. All right, am I alone? Are there other people around me? What are my options? So it's really put an emphasis on being thoughtful in why are you using the force that you're using?
And for the content of training on use of force, would you expect that training to include not only when to shoot, but also to include other levels of force, including when to use a taser or other device, similar device?
Correct. So it's going to really, be emphasizing, is it necessary to shoot, not shoot? Is a taser necessary, or are there people around that can assist you? The range staff does a fantastic job with that, and they have been some of the ones that best understood the need for us to get our officers in a position that they really work to assess the totality of the circumstances and engage in strong decision making.
And with these trainings on March 28th, 2020, that means they were approximately 2 months before the May 30th incident, which led to Mr. Gardner's dismissal. Is that correct?
That would be correct, yes.
Okay. I want to take you to that day on May 30th, 5 days after the murder of George Floyd by Minneapolis police officers and in connection with protests in Atlanta related to Mr. Floyd's death. What was the APD's role the evening of May 30th, 2020? That was a Saturday.
Oh, that was the Saturday. Well, we had an extremely difficult and somewhat frightening night the night before. We had encountered levels of civil unrest and violence that I don't know if it's ever been seen at that level, at least not in my 25 years, and I don't know if in the city, to be fair. And it was a confluence of agendas that came forward. Many people just wanted to protest George Floyd's killing and police brutality overall. But unfortunately, you had people who inserted themselves in the protests as a means of just creating havoc. Much of what we've seen in other parts of the country since then, to include at the Capitol. And it was extremely difficult to get a handle on. And it was a powder keg. We were sitting on a powder keg. We were managed to reel things back in Friday night, but we knew we were going into Saturday sitting on a powder keg. And we just wanted to navigate out of it safely without loss of life. And we went into Saturday better positioned because we simply had more people available, both internally, because at APD on that Friday, we had shifted so many people to work the morning because I believe it was Vice President Pence had come into town that day. But also we had all of these, our staff was there for the protests in the evening. And we also honestly had the National Guard numbers. And it made a difference because we had so many different locations to secure, whether it's Ebenezer, the King Center, Lenox Mall, it takes people. And so we felt that we were on much better footing of just hopefully quelling the violence and the civil unrest. I was feeling really good about where we were going compared to the night before. I mean, it was still overwhelming and daunting, but it didn't feel like we had lost control. It felt like if we just continue to manage this as we know how to in APD, we can get through this. And we were doing well. And then this video of the officers making the arrest on the students in the car was brought to my attention. And I knew then that we had just landed. Initially I didn't realize how bad it was going to be. And the longer it went on, the worse it got, because the more information I got about the incident. And I was very concerned Saturday going into Sunday that APD had lit a powder keg. We had put ourselves back by a considerable margin from where we were earlier in the evening.
And was there a curfew in place that evening?
There was. That curfew had been established. I believe that was the first night of it. I think when we discussed this, it's 9 o'clock, I believe it was. I think this came up in the last hearing. So I believe that's when it was, yes.
And was the goal of that curfew to address pedestrians in larger groups?
Right. So what we wanted to do, what we were trying to do is the folks that wanted to march and protest were not the issue. But the problem was the individuals inserting themselves inside these massive crowds that wanted to start fires, that wanted to shoot off guns, that wanted to tear down the city, destroy property. The only way that we could zero in on the people who were there for destructive purposes is if we had the lawful abiding people, please go home. That way we can see who is malingering that has ill intention. So the curfew was really to say, we need you to leave so we can focus our intentions on the people who are doing their darndest to tear the city down.
And given the climate and the media coverage, would you say it was especially important that evening for officers to follow APD Work Rule 4.2.50 on maltreatment or unnecessary force?
I would go beyond that and say it wasn't, the media coverage was there, so it's important, but the reality of it is the protests themselves were due as a result of police brutality. So you have to know what these folks, what are they protesting? It's excessive force by police. So that for me is why it created the greatest sensitivity.
And the conduct leading to Mr. Gardner's dismissal occurred that evening of May 30th. On the next day, that Sunday, May 31st, did you watch body-worn camera footage that was recorded on May 30th?
I did.
And we are going to now show you and the board some clips of that same footage you watched. I will note for the board that these are exhibits marked City 10 through City 14, and they have all been stipulated into evidence. There are excerpts from 5 different body-worn cameras for APD officers who were present during the May 30th, 2020 incident leading to Mr. Gardner's termination. We'll start by playing Mr. Gardner's body cam footage first, which is City 10. And based on feedback the last time we showed lots of footage, we're going to divide this into some smaller sections and just describe it as we go along.
Okay.
We are again happy to answer any questions the board may have about the footage or to replay any footage you'd like to see. Again, we're going to start with City Exhibit 10. You will see in this video footage, Mr. Gardner deploy his taser device against Ms. Pilgrim on the passenger side of the vehicle, and that will be at approximately 21:46:05. You see in the upper right-hand corner, that's where the timestamp is for Mr. Gardner's body camera footage. And so you'll see this at 21:46:05. We'll play the video all the way through, it's just under a minute, and then we'll come back to the moment right before the device was deployed and when it was deployed so we can confirm, and you will see for yourself those times. So we will now play City Exhibit 10, which is Gardner's body cam footage. And let me pause. We cannot hear, at least I cannot hear the video.
Mm-mm.
Nor can I.
Put the car apart! Put the car apart! Get out! Get out! Get out! Get out! Get out! Get out!
Wait, what's going on? I'm not even outside.
Put it in park! Put it in park! His pocket! His pocket! His pocket!
Chief Shields, do you recognize this footage as video you reviewed on May 31st, 2020?
Yes.
And do you see from the angle of his body-worn camera, Mr. Gardner approached the car and specifically the passenger side?
Yes.
Okay, we're gonna go back and show you and then pause the video at the 46:04 mark or as close to as possible. And Chief Shields, what I want to ask you is for you to look at the timestamp when we first hear an officer saying, put the car in park, put the car in park.
Put the car apart!
Did you see the timestamp of 21:46:03 for when we first hear that statement from the officer?
I actually saw 4, but 3 or 4, yes.
Therefore, okay. And we don't know whether that voice belongs to Mr. Gardner, but for me who has watched this video many times, and I know you have as well, it sounds like it could be a different officer. Is that common that you don't know the voices on a body cam?
Correct. When
Sometimes.
there's this, yes, when there's multiple things occurring at once, that is not uncommon.
We're going to play it forward again and pause at approximately 46:05. Chief Shields, what I want to ask this time is for you to pay attention to the approximate timestamp when Mr. Gardner deploys his device against Ms. Pilgrim. And let me ask you, do you know if that's a taser or another brand?
It should be a taser. That's what we use, the Axon taser.
Okay, so I'm going to ask you to pay attention to the approximate timestamp when Mr. Gardner deploys his taser against Ms. Pilgrim. Do you agree that Mr. Gardner deployed his taser around 21:46:05 on this
Yes.
video?
Yes,
So approximately 1 to 2 seconds elapsed between hearing an officer's command about putting the car in park and a taser being deployed against Ms. Pilgrim, the passenger.
correct.
And would you agree a passenger of a vehicle could quite possibly have a difficult time getting the car into park? Not the driver, but the passenger.
Correct.
And beyond him potentially yelling to put the car in park, do you hear on this body cam footage from a camera worn by Mr. Gardner, do you hear Mr. Gardner say anything at all to Ms. Pilgrim before he takes out his taser and deploys it on her?
I didn't know.
Next, we will show you City Exhibit 11, which is body cam footage from Officer Roland Cloud. And this is footage directly after Ms. Pilgrim was subject to tasering, and you will see her on the ground asking repeatedly what she did.
Wait, what did I do? What did I do? I haven't even got no. Can we let you 6-7? Okay. 6-7, let's just come 46. Go ahead, 14-15.
And Chief Shields, do you recognize this footage, this video you reviewed on May 31st,
It was
2020?
yes, it was one of the ones.
Next, we'll look at City Exhibit 12, which is body cam footage from Sergeant Sheldon Drinkard. It starts right before the incident with the taser, that you can see Mr. Gardner behind other officers on the right side of the screen, coming up to the passenger side of the vehicle with his taser. I'm going to pause the video to highlight where Mr. Gardner is so that we can all find him.
Southbound Ted Turner, black, no all black. Southbound Ted Turner.
Put the car apart! Put the car.
And Chief Shields, do you recognize this as video you reviewed on May 31st, 2020?
Yes, it is one of the ones we reviewed.
Next, Exhibit City 13, which is body cam footage from Officer Carlos Smith. It starts before the incident where Ms. Pilgrim is subject to the deploying of the taser device, and ends after the driver, Mr. Young, has also had the taser device deployed at him. I'm going to pause this video a few times to ask you questions as we all review it. Let me start by pointing to where the yellow rectangle is. Do you see the officer with the helmet that says M. Gardner in the middle of the camera?
Yes,
And I assume that's Mark Gardner. I know you weren't there. Do you believe that's Mr. Gardner as well?
yes.
Okay, we'll continue the video.
Southbound Ted Turner, black, no all black. Southbound Ted Turner.
Put the car apart! Put the car apart! Put the car apart! Car apart!
Wait, what's going on? I'm not.
And Chief Shields, at this point in the video, Ms. Pilgrim has already been tasered by Mr. Gardner and removed from the vehicle. Is that correct?
Yes.
I'm going to continue the video here, and you will see Officer Smith continue on to the other side of the car.
Even outside? Wait, what happened? What happened?
Watch your back, watch your back, watch your back.
Everybody is good here now.
Chief Shields, did you hear an officer yell, "He's got a gun, he's got a gun"?
I did.
And at what time did you hear that happen per the paused video?
21:46:38.
And I would just ask you, was it 37 to 38? You think it was?
Correct. It's paused at 38, but I would say it's fair to say it was at 37 we first heard it.
Okay. 37 to 38. And at the time that the officer yelled about a gun, Ms. Pilgrim was already on the ground, right?
Correct.
She had already had the taser deployed at her, on her, and had been removed from the vehicle and pushed onto the ground, correct?
Yes, correct.
And in fact, the officer yelling that there was a gun happened approximately 30 seconds after Ms. Pilgrim was tased, correct?
Yes, correct.
Okay, we'll continue finishing the rest of this exhibit, City 13.
You got a gun.
Chief Shields, do you recognize this exhibit City 13 as one of the videos you reviewed on May 31st, 2020?
Yes, it is one of them.
And in any of the body cam footage you viewed of this incident, did you ever see the driver or passenger with a weapon?
No.
Do you know if a gun or other weapon was ever recovered from the car, passenger, or driver?
One was not recovered.
Finally, I want to show you City 14, which is body cam footage from former APD Sergeant Lonnie Hood. This one is a bit longer and shows more of the lead up to the incident, with the driver filming the police and then a better view of Miss Pilgrim being tased by Mr. Gardner. So you will see the prongs shoot out from Mr. Gardner's taser at about 46:04. I want to make clear that the hands you see with the taser belong to Officer Hood, we believe.
He's getting in the car. He's getting in the car. He's with us getting in the car. If you don't go, man, you don't go to jail. If you don't go, you don't go to jail. Alright? If you don't go, you don't go to
Right, do you think that's what this goes? What do you think? Go ahead, 14, 15. Chief Shields, just for those of us who have not been to post training and not had one-on-one interaction with the tasers, I'm going to ask my staff to go ahead and bring that back up, that video we just saw, because I want to just let you explain to us those. I'm sure there's a technical name for those things that come out of the taser. Can you just tell us what's happening there for those of us who are laymen?
So the taser shoots out prongs. They're like fish hooks, and they go into the.
Could we pause a second? I just got a message that the chair lost contact. So we probably need to take let's take a 10-minute break, give him a chance to get back on. Okay.
Thank you.
All right. 10 minutes. So we'll come back at 11:11. Okay.
Thank you.
All right. Thank you. Okay, Robert, I gave a recess until 11:11. But take your mute off. Robert, take your mute off. Yeah.
Do we know what happened?
No, it only happened to you.
Oh, jeez.
Yeah, it only happened to you. So everybody will come back at 11:11.
Okay,
Okay.
thank you so much.
All right. Mhm.
Lehman, where are we on time?
We are, let's see, the city has 18 minutes and then 30 minutes. So he's on 48 minutes. City has 48 minutes that they have done. They've had 48 minutes.
So they have till, because they started at 10:30 to 11:30.
Well, what they
Oh,
have,
okay.
they'll have to pull the break part out, but
Right,
what they have is a 90-minute total. And so
okay,
she's done 48 now.
So
okay.
technically, we should probably give them until 1:15 for the entire session. Or should
Well,
we keep it until 1?
you know, she has the question. She has the question, her witnesses too. So
Right,
her total
Yeah,
time,
I
this
just,
is going by total time. relative
Yeah.
to clock time.
okay.
yeah, I just wanted her to know how much more time she had to get a little warning.
Yeah.
Miss-
So-
Mr. Hawkins, did you see the message I sent you in the chat?
No, I didn't. I was so focused on those videos.
No,
What did
no,
you
it's
tell me?
okay.
Apologies, Ms. Harmon, I'm coming into this late, but I heard you talking about how much more time was available, and in case any of us were not on, could you repeat that?
The city has used 48 minutes. The total time for the city is 90 minutes. the total time for the appellant is 90 minutes. But as we said in the beginning, if the city cross-examines the appellant's witness, that goes on her time.
Yes, thank you. That's consistent with
Okay.
what we have, and we
Okay,
appreciate it.
so
Thank you.
48 minutes is where we are right now.
Thank you. We were just having that same conversation over here, so we appreciate that we're all on the same clock.
Robert, can you hear me?
I can hear you fine.
Okay.
Mr. Hawkins, I was looking at Chief Shields, so I'm not sure where we lost you. I don't know if you'll tell us when we go back on the record, but I just want to make sure that I uncover everything.
Oh, okay. Yes, I will tell you where I think we were when I lost connectivity.
Thank you.
About 60 seconds. Okay, let's go back on the record. The time is now 11:11. And when I lost connectivity, Ms. Hardy, I think you were presenting City Exhibit 14 with former Sergeant Lonnie Hood. So please pick up from there.
Okay, so perhaps we should go ahead and show this whole video.
I think that would be appropriate.
Okay, thank you. Thank you. City 14.
He's getting in the car. He's getting in the car. He's with us getting in the car. If you don't go, man, you don't go to jail. If you don't go, you don't go to jail. All right? If you don't go, you don't go to jail. All right? And Chief Shields, do you recognize this footage as one of the videos you reviewed on May 31st?
Correct, it is one of them.
And I believe when we stopped, you were using your expertise to tell us about what we saw in terms of after the taser deployed there towards the end of the video. And I'll ask my staff to just move the video back a little to show what we're speaking of here. We'll just start right here. Great, thank you.
Can I explain?
And Chief Shields, you're welcome to speak over the
Okay.
video for the sake of time.
Okay. So I believe the question had been how does the taser essentially work? And what it does is when you pull the trigger, it's going to shoot out two, you saw those two wires referred to as prongs, fish hooks, probes, but they go into the skin, on the surface of the skin, and an electric discharge is put through the wires. It's like a 5-second burst of electricity. And the idea is you're immobilizing the individual who is resisting. And so that's what you would have seen occurring when you saw the wires enter into the screen.
And just so we're clear here, there are two different officers, Officer Gardner or Appellant Gardner and Officer Hood, who deployed taser devices. Is that correct?
Correct, yep.
Okay, and we'll just finish out the rest of the video so we can see it with that perspective. And Chief Shields, did you see at the beginning of this video, the student who was driving, Mr. Young, was filming officers with his cell phone?
Correct.
And I presume this has happened many times. You've dealt with this in your police force. At the time, on May 30th, was it the policy of the APD not to interfere with citizens filming?
Yes, it was. As I mentioned on the previous hearing, we had engaged in some litigation as a result of one of our officers obstructing someone filming years ago. So that has been that's been in our training and a policy for quite some time.
And did you hear conflicting demands from the various officers at the scene when watching this video?
There were multiple conflicting demands, yes.
How should a reasonable officer have handled Ms. Pilgrim on May 30th?
I think that when you, and this goes to the totality of the event, that you recognize that they could have walked up to the car and they could have told them to put it in park. They could have told her to get out of the car. I honestly believe that with a different mindset or different officers, this could have been a verbal encounter. I mean, if you were that intent on putting them in jail, then we introduced the force and we made it a force incident. There's no two ways about it.
We together today watched about 5.5 minutes of video. How many hours did you spend watching body cam footage before making a decision on Mr. Gardner?
Approximately 4 hours.
And what was your conclusion about Mr. Gardner's use of force after reviewing the body cam footage from May 30th?
I was disappointed, and there was no way. And I care for Mark, and we worked together for years, and this is not a decision I made lightly, but there was no way I could defend the force that was used.
Did you determine that Mr. Gardner's conduct violated APD Work Rule 4.2.5.0 regarding excessive force?
I did, yes.
Did you expect more from a member of the fugitive team?
More from a member of the fugitive team? Is that what you asked me?
Yes.
I would, yes. When you become an investigator, the idea is you're taking on a senior role, more of a leadership role, and knowing the years of experience on our fugitive team and the fact that they're on the street on a regular basis, so their tactics should be and are sharp. I would have expected this unit to perform at a much higher level.
Did you decide to dismiss Mr. Gardner for his violation of Work Rule 4.2.5.0?
I did.
Chief Shields, I'd like to show you City Exhibit 05, which again has been stipulated into evidence. It's Atlanta City Code Section 114.526. And the second sentence reads, when an infraction is such as to impair or destroy the future effective performance of the employee, or when the employee's presence impairs the effectiveness of others or presents danger to the employee, others, or city property, action shall be taken to immediately remove the employee from the work environment. Did Mr. Gardner's conduct affect the public standing of the APD?
It did.
Did his conduct erode the public's trust in the APD?
It did.
Could his continued employment have impaired the APD's effectiveness in working with the public?
It would have, yes.
And did you make the decision to handle Mr. Gardner's dismissal on an emergency basis?
I did, yes.
We will now show you City 01, which has been stipulated into evidence. The NPAA, is it marked as an emergency action?
It is, yes.
And why was that?
We had just managed to quell the unrest to a point, as I stated earlier, that we were still in a very, very tenuous state. And the reality of it is to go into Sunday night and not have addressed this and not shown the public that we were serious about officers and excessive force, that city would have lit up to levels I don't even want to speculate on. And what I will say is, yes, the decision was made quickly, and no, it was not ideal. But what I can tell you is we could have waited a month, 3 months. It wasn't going to change the outcome. The force was excessive for what the officers were presented with.
And I have heard you say that the city was a powder keg and on the cusp of catching fire. Do you still believe those statements are true?
Oh, I know they are.
And what did you weigh in determining not to wait longer before dismissing Mr. Gardner's employment with the APD?
We were in such a tenuous state that the slightest thing was just, it was going to trigger rioting and protests at levels that exceeded the Friday night. And I mean, and that was extremely dangerous. And the other thing is, every time that we were putting officers in this environment, the greatest likelihood of injury to be in the midst of this was to the officers. And so to not deal with it or to allow more time so that one employee could have more of a established process would have been subjecting thousands of others, our employees, the other agencies, National Guard, to continued violence. And the decision was made to expedite the termination so that hopefully we could get through Sunday night without there being those levels of violence that we had previously experienced.
Did the notice provide Mr. Gardner with a time to respond?
Yes.
And did he do so?
He did, yes.
Did he give you a statement about what happened?
No, so he and investigator Streeter, they both were waiting on the union rep who was not there. And, you know, I wish, again, I had the luxury of time to allow them to at least have the process and so that you know what, they weren't going to feel any better. The union rep could have come, the facts remain the facts. But no, statement was not provided as the union person was not there yet.
Would a statement have affected your decision to dismiss Mr. Gardner from the APD?
No.
Okay, Chief Shields, I just have a few more questions and then we'll move on. for timing purposes. I want to show you Exhibit City 09. Again, it has been stipulated into evidence. And this is Mr. Gardner's report of the May 30th incident. If you look at the first page, it says this report was prepared at 1 p.m. on May 31st. Is that correct?
Yes,
And are we to understand that Mr. Gardner was the person who prepared this report?
his name is there, so yes.
Did you have access to this report on May 31st when you were considering discipline for Mr. Gardner?
I did.
And I want to direct you to the second page, second paragraph, second sentence. Do you see where Mr. Gardner wrote, "I approached the passenger side and gave verbal commands to the female to show her hands and stop resisting. At this time, I heard officers say gun 2 to 3 times. Not being able to see the hands of the passenger, and being that she was in my immediate sight, I deployed my city-issued taser to defuse the situation and bring the female passenger under control." Now, based on the videos you watched on May 31st, 2020, and the excerpt that we have all seen today, did you hear Mr. Gardner give verbal commands to Ms. Pilgrim to stop resisting?
No,
Did you hear him tell Ms. Pilgrim to show her hands?
no,
In fact, all we might have heard is him or another officer saying, "Put the car in park," before Mr. Gardner tased Ms. Pilgrim, correct?
correct.
And based on the videos that you watched on May 31st, 2020, and the excerpts that we all saw today, did you hear an officer yell gun before or after Mr. Gardner deployed his taser against Ms. Pilgrim?
It was after.
And if I believe you testified, it was about 30 seconds after he had deployed his taser. Is that correct?
Correct. It was after she was removed from the vehicle.
And Chief Shields, do you have concerns with the truthfulness of Mr. Gardner's report? That is Exhibit City 09, as we look at it here today.
Yes,
If you had not terminated Mr. Gardner in an emergency fashion on May 31st for use of force, would you have pursued investigating whether Mr. Gardner was truthful in his report of the incident?
yes,
And could being untruthful in a report about use of force also lead to the discipline of Mr. Gardner?
yes.
In the interest of time, I will tender the witness. Thank you, Chief Shields.
Thank you.
Okay, Mr. LoRusso, cross.
Thank you.
Okay, excuse me, Mr. LaRusso, just one second. We have someone there that would like to identify themselves, introduce themselves to the panel, please. When this exhibit is taken down. I believe we have a Mr. Yes, Mr. Robertson. Would you identify yourself, please?
Yes, ma'am. I'm Senator Randy Robertson. I represent District 29 in Georgia, and I sit on the Senate Public Safety Committee in the role as secretary.
And you are here as what? As for the appellant, for the city?
I'm
Who
here
were
as
you invited by?
an observer to listen to the information that was brought. There was much testimony made in the legislature last year surrounding this incident and others. And basically, I'm just here listening. I have no intention of partaking in the procedures at this time.
Okay, please give me your title again, Mr. Robertson.
Yes, it's State Senator for Georgia, District 29. And I'm a use of force expert and a prior law enforcement officer.
And who subpoenaed you to this hearing?
No one subpoenaed me.
I guess I'm just trying to figure out how you got on the.
He's a public person. Public. He's a
Okay,
public observer.
okay.
We normally don't have their picture up, but he's part of the public observation.
Right. I
Okay,
wasn't
thank you, Mr.
engaging.
Mhm. Yes, Mr. Robertson?
Yeah, I said I was not planning on engaging. I was only listening.
Oh, okay, okay. We want to make sure everybody's on that we know, because, you know, we have to write it up and your name will be included in our report. So we need to make sure that we know who is on this hearing in your capacity, in our capacity.
I appreciate the
Okay.
professional. Thank you.
Thank you for introducing yourself.
Yes, ma'am. Thank you.
Okay, thanks, Mr. Robertson. Mr. LoRusso, Cross.
Good morning, Chief Shields. Question so far as the employee disciplinary process, if we could pull up disciplinary process policy on page 27, 4.8.4, it's been stipulated as A4.
Got it?
The statement says that any response to a notice of proposed adverse action will be tape recorded. Did I read that accurately?
Yes,
And you've certainly done these before, correct?
yes,
And any response was not recorded. There's absolutely no recording of the interaction that took place between you and Investigator Gardner on May 31st.
that's correct.
And nothing prevented you from recording that interaction you had with him, correct?
Well, I would have recorded if we actually had a formal response session.
And it's your opportunity, it's your obligation to give him an opportunity to have a formal response session, correct?
Yes,
And you didn't do that, did you?
I did, but they could not in the time that they were allocated. They wanted to wait on the union. Had the union been there, we would have moved forward with it.
And they're entitled to have a union rep or an attorney with them, correct?
They are.
And it's your testimony here under oath that Investigator Gardner did not have a union rep or attorney with him at any time during this process, correct?
That is correct.
Now, if we can go to 4.8.2 subsection D on page 26 of the same exhibit. The purpose of the time frame between the notice of proposed adverse action and the notice final adverse action is to give the employee an opportunity to review the investigative file and obtain legal or other representation, correct?
Correct.
So the time frame is not just a matter of convenience. The time frame is to allow the employee to prepare a personal response, correct?
That is correct.
And if we can look at, excuse me, on the same page, 4.8.32B. It's not a full evidentiary hearing. It's a special effort within the personnel management function to afford the accused employee, and look at B, answer questions the disciplinary authority may have. Did I read that accurately?
Yes, you did.
And you have no idea from his mouth why a 23-year veteran trained by the FBI, trained by the city of Atlanta, and serving on one of the most elite units in the department deployed his taser on Tanaya Pilgrim, do you?
I have an idea, but no, I did not hear from him.
So the answer is no, you never asked him a single question, did you?
That's correct.
And as far as you know, nobody ever asked him that question.
I
Correct?
don't. No, I don't. I would disagree with that. I think we were getting mixed messages the night previous when we were first finding out about the media, the event through the media. I believe that their supervisor had spoken to him and others in the unit.
And we're going to hear from Captain Schiefbauer later. That was his supervisor, right?
No, I was thinking of Lieutenant Baines.
Okay. And if we look at 4.9.2 on the disciplinary process, you stated this is an emergency disciplinary action, but section 1 states specifically there should be at least 5 working days between the date of the notice of proposed adverse action was issued and the date scheduled for the employee response session. Did I read that accurately?
Ideally, that is what we aspire to. Yes.
So it's your testimony that all of the policies and procedures of the Atlanta Police Department are mere aspirations?
No, but What I will say is the circumstances were exceptional. You cannot find where we were in an environment like this previously. This was truly exigent circumstances, and we did what we had to do. I did what I had to do to ensure that that city was stabilized.
And when Investigator Gardner was faced with somebody telling him there was a gun in the car, he did what he had to do too, but you didn't have his back, did you?
That came after he had already tased and put the passenger on the ground.
And that's what Ms. Hardy brought out, but you didn't ask Investigator Gardner who actually said that, did you?
Well, it was still after the fact.
Because you were just reviewing the videos, because that's the only thing that you heard. You don't know what Mark Gardner heard, right?
Well, we were there with them and we've reviewed all of the audio from all of the tapes. So I think it's fair to say we have a fairly good idea of what occurred.
You said we were there with him, we not being you in the operative sense, because you were in an Operation Command Center driving around, right?
I was not at the scene of the incident. That is correct when it occurred. Yes.
So there's been a lot of talk about ordinances. So let's look at A16 and section 114.532. If you look at section A, it says the appointing authority may immediately suspend an employee if there's an emergency circumstance that exists. Did I read that accurately?
Yes,
And you certainly know these ordinances. These shouldn't be new to you, correct?
that's correct.
And on section B, it says the appointing authority or designee shall give the employee against whom the emergency action is taken a notice of emergency action in writing not later than 5 working days after the effective date of the emergency action. You never provided that to Investigator Gardner, did you?
Correct.
So the answer is no, you never complied with this city ordinance, correct?
Well, I would disagree. I conferred with the law department, and I feel that when you look at the totality of the ordinances, we were in compliance with the city ordinances.
So now we're talking totality of ordinances instead of strict obeying. I'm almost done with my question. So now you're talking about totality of the circumstances instead of complying with the black letter law of a city ordinance, which has the effect of law. Is that your argument to this panel?
No, I think that lawyers often disagree, and there are lawyers in the city of Atlanta who don't interpret the ordinance the way that you do, because there are other ordinances. They're not all, it's outside counsel believed that we were acting in accordance with the city ordinances.
I just want to make sure I caution you against providing any privileged information in response to Mr. LoRusso's question.
Understood.
Actually, I'd prefer you just stick with the words in the ordinance. So let's look at the next sentence. The notice of emergency action shall include a statement of the emergency situation that caused the action to be taken. I read that accurately, right?
Yes.
And you never did that either, did you?
Nope.
Let's look at A17, which is the notice of proposed action. And on the notice of proposed action, you have a blank that says in the middle, notice narrative, reason for adverse emergency action. And that section's completely blank. You never took the time to fill that in, did you?
We never fill out the sheet. The reasoning is in the body that you just scrolled through. We always just put what the final disciplinary action was. But the narrative is on page 2.
Okay, well, we look at page 2. It doesn't say all this nice stuff that you provided for Ms. Lawrence Hardy, that the city was going to burn and the reputation of the department was at issue and we were in unprecedented times. There's not a single statement justifying an emergency action on page 2, is there?
I think that there is. I think if you know the timing of the incident, you know that there was.
Well, the board will be able to take that for themselves. Now, on the notice of final adverse action, which is also in the same exhibit, on emergency action, you have typed no, correct?
That's a typo.
Oh, that's a typo. Okay, so let me ask you this, where it says at the top of the notice of final adverse action, where it says notice of proposed adverse action issued on, says, did the employee respond? You have yes. Is that another typo?
No, I put that because it was important for me. We have employees, especially when it's emergency actions, who just never show up. And Gardner and Streeter did show up. They chose not to meet with me because the union rep wasn't there, but they did show up. And I think it's important to acknowledge that they didn't just blow off the process entirely.
But you said they gave no response and chose not to give a response. I wrote it down. You said it 3 times. They chose, now I'm almost done.
Mhm.
They chose not to give a response and to wait for their union rep. Yet you checked personal response. That's not accurate, is it?
It is accurate. They came, they personally responded, but they did not provide a formal response. And it is the formal response session that we record and we have on record. My conversation with them was, we need to do this now. And they did not want to move forward without the union rep. So.
And I think to shorten this, you said you didn't want to wait 20 minutes. You couldn't do that, right?
That's correct.
Okay. Mark Gardner went to work for 23 years. You couldn't give him 20 minutes?
That's correct.
Too inconvenient. You agree that this is a priority 1 complaint. If we look at the disciplinary process on 46, 5.26, correct? It's of a serious nature, involves employee contact that was involved unauthorized force. So that's it's priority 1 complaint, right?
Priority 1 is use of force, yes.
And it specifically states that OPS will do an investigation in a priority 1 complaint, does it not?
It does, and ideally that is the process.
Well, nothing prevented that. You just made a judgment call, right?
I did so out of an abundance of caution and knowing the precarious situation that the city was in.
Let me show you what's been marked, what's been marked the conducted energy weapon policy. And that is Exhibit 3, I believe. No, it's Exhibit 1, excuse me, A1. We're going to pull that up. The conducted energy weapon policy, you would agree that's relevant to these proceedings, would you not?
Yes.
I mean, you fired these officers for not complying with the conducted energy weapon policy. And if we look at page 2.
I'm sorry, Mr. LoRusso, is that a question for Chief Shields?
It sounded like it.
Well, let's allow her to answer then.
I wasn't done with it, but it was a question. On section 3.7 on page 2, it says specifically, the Office of Professional Standards shall investigate suspected employee work rule violations arising out of an employee's use of a CEW in accordance with the disciplinary process policy. Did I read that accurately?
You did.
But you did not give the OPS unit a time to investigate that, did you?
It wasn't an option, no.
Well, it was an option under policy. You just chose not to do it, right?
No, it wasn't an option, not in the environment we were in.
And when a person is terminated, let's go back to the disciplinary process, page 28, 4.8.4. A member of the advocacy unit or a city attorney will attend the employee response session conducted at the chief's level. Now, you're at the chief's level, so they're supposed to attend, right?
Correct.
And nobody from the advocacy unit or the city attorney was present when you terminated Investigator Gardner. Isn't that correct?
That is incorrect.
Is your testimony that there was a city attorney with you when you met with Mark Gardner?
Yes.
Okay. Let's go to Exhibit 35. This is an email that you put out to the department following this incident on July 2nd. Do you recall this email?
Yes.
And you described the situation as highly dangerous and unpredictable.
Yes.
And you stated we gave conflicting instructions. Now, how many times was Messiah Young, the driver of the vehicle, told to leave the city and drive away? Did you count those?
I don't know, several times.
If I told you 10, would that be consistent with your 4 hours of review?
It's, if it's 10, it's 10.
And he didn't comply with those, did he?
Well, he appeared to try to leave.
And then he was approached by an officer because he was refusing to leave and was backing up traffic. Did you see something different in the video?
Oh, I mean, he wasn't backing up traffic. As the officer said, there was nowhere for anyone to go.
So this interaction took place 40 minutes after the curfew, correct?
It was after, but I'm not sure of the exact time.
Well, you were sure of it when you were looking at Ms. Allegra Lawrence Hardy. You said 21:46. That's
Oh,
40
that's fair.
minutes after 9 o'clock, right?
That's true. Thank you. You're correct. Thank you.
So Messiah Young and Tanaya Pilgrim were subject to arrest when those officers approached the car for violation of the curfew, correct?
Yes.
After this, one second. The Exhibit 16, the notice of proposed adverse action, you gave Investigator Gardner and Investigator Streeter, but Investigator Gardner till 6 p.m. It says 6 o'clock. That's 6 p.m. to give his personal response, right?
Yes.
That was a deadline that you set?
Yes.
Now, the policy says 5 working days for at least 5 working days for an emergency action, and this was a Sunday, so 5 working days would have been Friday, the 5th, correct?
I believe it's up to 5 working days, isn't it?
It says at least, but you should have given him at least until Friday, June 5th, which would have been 5 working days according to the ordinance, correct?
Regardless, it wasn't an option whether it was 1 day or 5 days. It was time sensitive, and there was an absolute sense of urgency.
And there wasn't anything special about May 31st at 6 p.m.?
What was special was that we needed this addressed before the sun went down, or we were potentially facing extreme civil unrest.
That's it, though, right? That's the only thing?
That was what drove us making that dismissal that day.
I may have some recross, Mr. Hawkins, and I did not say this at the beginning, and I think Ms. Lawrence Hardy also overlooked it, but we would ask that these witnesses be sequestered, and I believe Ms. Harmon is doing so very well, but we have to cross our T's and dot our I's.
So noted. Ms. Hardy, redirect.
Brief, sir, thank you. I'd like to go back to the exhibit we just looked at, 532. Mr. LoRusso, if your office will put it back up.
Sure, hang on. Can you put that back up? It's exhibit
A60. And Chief Shields, just to look at this document again, you were asked lots of questions about it, and you were asked to read various parts of it. I want to just make sure we all take a moment to read there at the very beginning where it says 532 applies to suspensions. Is that correct?
The emergency situation, yes. Suspend the employee with pay upon, yep.
Thank you. We can take it down now. Thank you, Mr. LoRusso. And now I'd like to ask my team to please put up City 06, which has been stipulated into evidence. And this is section 1114, 530 of the code. Section 530. So the actual relevant section here, and it reads, an employee against whom an adverse action is to be taken shall be given a written notice of proposed adverse action signed by the appointing authority or designee at least 10 working days prior to the effective date of the proposed adverse action. However, in an emergency situation, the adverse action may become effective immediately following the employee's response, if any. Is that correct, Chief Shields?
Yes.
And are you familiar with this language allowing dismissal to become effective immediately following an employee's response, if any, in an emergency situation?
Yes, I have reviewed this before.
And when we look at the differences between a typical non-emergency dismissal and an emergency dismissal, there's no requirement for an OPS investigation for an emergency dismissal. Is that correct?
That is correct.
And in an emergency situation, you are not required to obtain a statement recorded or otherwise from the officer, correct?
That's correct.
And in an emergency situation, there is not a certain number of days that must pass between delivering the NPAA and the NFAA, correct?
Correct.
And instead, in an emergency situation, the dismissal may be effective immediately after the employee's response. Is that correct?
Correct.
And we know that from this code section 530. And let me just ask you as a final question, if there's a situation where the SOPs and the code conflict, what governs?
Oh, the code does.
Thank you. No further questions.
Recross.
Chief, the policy, the ordinance that you wrote says remove from the workplace. It doesn't say terminate, does it? You could do two different things. You could remove somebody from the workplace pending an investigation, right?
That would seem fair, yes.
Now, you mentioned that you recall being at a press conference when the mayor said the chief and I made the determination that two of the officers involved in the incident last night will be terminated immediately. Do you recall that?
Yes.
And she said the chief and I. She didn't say Chief Shields made the decision, did she?
I believe she said the chief and I.
And the two officers she's talking about are Streeter and Gardner, right?
Correct.
And you told this board only you had the authority to fire the APD officers, right?
Correct.
Now that press conference took place on May 31st. It was set for 2 o'clock, but it was moved till 6 p.m., wasn't it?
It was moved. It was moved multiple times. Yes.
So the press conference actually wound up taking place at the exact specific time that you put the deadline for these officers, specifically Investigator Mark Gardner, to give you his personal response. That's why you didn't have time, right? Because you had to make sure the mayor could announce that he was fired.
No. It was the conduct, and it was getting it out there before the dark. It became dark. We were sitting on a powder keg. It had to be addressed.
I don't have any other questions, Mr. Hawkins. Thank you.
Ms. Hardy, do you have any other questions?
We do not. Thank you. And with that, we rest.
Chief Shields, thank you so much for your testimony. You're free to go. We would ask that you not discuss your testimony with anyone outside of this hearing. Thank you so much.
Mr. Hawkins, we would ask that she be held in case there is any rebuttal that needs to be brought up. We'd ask that she just be reserved.
Any objections with that, Ms. Hardy?
No objection from us. And we also, of course, before Mr. LoRusso begins presentation of his case, want to also renew our request for sequestration of all witnesses.
Okay. Ms. Hardy, please call your next witness.
That is actually our only witness, Your Honor. So we now we rest.
Okay. Mr. LoRusso, please call your first witness.
Mr. Hawkins, our first witness is retired Major Rick Mason, and in the interest of time and keeping Ms. Harmon from going crazy trying to keep up with lawyers in this environment, the next witness will be SPO Paul Norman Merritt, and the witness after that will be now Major Brian Schiefbauer, Ms. Harmon. Hopefully that helps you out a little bit.
Is Mr. Mason online?
Okay, give me just one moment. You said Rick Mason?
Yes, ma'am. Next will be Merritt, and then Major Schiefbauer after that.
Perfect, thank you.
Yes, ma'am. Major Mason, can you hear me? I do see you're popped up there.
I can hear you.
Okay. Can you raise your right hand, please? Do you swear?
I will take care of that, Mr. Mason.
Okay.
Are you able to hear us okay?
Yes, sir.
Okay, do you have any objection to taking an oath?
No, sir.
Please raise your right hand. Do you swear or affirm to
Done.
tell the truth?
Yes, sir.
Would you please state your name, your job title, and years of service with the city?
Richard Mason, retired police major, just under 28 years with the city of Atlanta.
Thank you. Mr. LoRusso.
Excuse me, Mr. Chair, Mr. Russo, we cannot see Mr. Mason. Is that intended?
No, I can't see him either. I know that. Oh, there we go.
Okay. Thank you. Thank you, Mr. Mason.
Can you state when you retired, sir?
August 31st, 2020.
And you had how many years with the city?
Just under 28, more
When
than
you
27.
When you retired, were you in any command level positions as a major?
I was the director of code enforcement, and then I was recently transferred to Zone 5, downtown Atlanta.
Now, at the time that these events took place, I want to call your attention to May 30th and May 31st, 2020. What was your role with the city on those dates? Were you called out of your normal role as code enforcement?
I was called to interact with the protesters at the most violent and aggressive areas of the city.
Can you briefly, because we are on a time constraint, describe for this board, put us on the street at that time, what it was like for a police officer to be working on the streets of the city of Atlanta on May 31st, 2020?
It was the worst I'd seen in my more than 27 years with the city of Atlanta. It could go from quiet to utter chaos instantaneously. There were fireworks and mortars and gunshots and bottles and bricks. Anything you could ever imagine occurring was occurring instantly throughout the city.
At one point, at some point, did you employ the use of 400 and then 600 National Guardsmen to attempt to gain control of the streets?
I did. I was part of that operation.
And was there a mandate of arrest from the executive order based on the curfew that was put in place?
We were under a directive that the curfew was at 2100 hours and everyone that was still out was to go to jail.
And who did that order come from?
That came from the mayor down the chain through communications to us.
Do you recall a broadcast by the chief of the City of Atlanta Police Department, Erica Shields, that if people are on the street after 2100 hours or 9 o'clock, they're to be taken to jail?
Correct.
I'm going to, in the interest of time, I'm going to move forward. Did you have an opportunity to review the videos of the arrests of Messiah Young and Tanaya Pilgrim that are stipulated at A41 through 44?
I did.
And you are familiar with the policies and procedures of the City of Atlanta and the ordinances of the City of Atlanta and state law regarding the lawful use of force by a law enforcement officer to effect an arrest as they were in place on May 31st, 2020?
Yes, sir.
Did you observe any violations of state law during the arrest of Tanaya Pilgrim or the arrest of Messiah Young?
No, sir.
Did you see any violations of City of Atlanta policy 4.2.50, maltreatment or unnecessary force, in the arrest of Tanaya Pilgrim?
No, sir.
Did you see any violations of any Atlanta policy by Investigator Gardner in any way on the videos regarding the arrest of Tanaya Pilgrim?
I did not.
With regard to the arrests of individuals, are you aware that when people were arrested, if they didn't have identification, they were turned loose and let go?
I was not aware of that.
That would be completely inappropriate, wouldn't it?
That would be appalling.
That would be, I'm sorry, appalling. Okay.
Appalling.
That's all I have right now, Mr. Hawkins. I may have some follow-up.
Ms. Hardy?
Thank you. Mr. Mason, you were not physically present at the scene when Mr. Gardner tased Ms. Pilgrim on the evening of May 30th, 2020, correct?
Correct. I was a block away.
And you agree that the chief of the APD is the only one who has the authority to fire an APD officer?
Correct.
And would you agree that the chief of police has to exercise judgment when she makes a decision on whether to terminate an officer?
I would hope that she would be objectively reasonable.
Is that yes?
I would hope that she would use judgment, yes.
And you were not the chief of police when Mr. Gardner was fired, correct?
Correct.
And you've never been a chief of police, is that correct?
That's correct.
And in fact, you were not part of the decision-making process in any way for Mr. Gardner's termination, correct?
Correct.
All right, thank you so much for your time. That is all that I have for this witness, Mr. Hawkins.
Redirect, Mr. LoRusso.
I have no follow-up, Mr. Hawkins. My next witness would be.
Can you hold on 1 second?
Yes, sir.
I want to give my board members an opportunity to ask any questions that they may have of this witness.
No questions from me, sir.
I have no questions. Thank you.
Okay, no further questions for Major Mason?
None from us, Your Honor. Thank you.
Okay. Mr. Mason,
Yes, sir.
free to go?
Thank you, sir.
And please do not discuss your testimony with anyone outside of this hearing.
Understood.
Thank you. Please call your next witness.
Our next witness will be SPO Norman Paul Merritt. Ms. Harmon, for your benefit, Major Sheaf Farrell will be next, and then Lieutenant Peterson will be after that. Put those in place. I believe he's on, sir.
I can't see him. Mr. Mason, are you with us, Mr. Merritt?
He's muted.
Okay, how about now?
We
Can
can
you
hear
hear
you now.
Great, thank you.
Mr. Merritt, do you have any objection to taking an oath?
I do not.
Please raise your right hand. Do you swear or affirm to tell the truth?
I do.
Would you please state your name for the record, job title, and years of service with the city?
My name is Norman Paul Merritt. I am a senior patrol officer with the City of Atlanta Police Department. I've been in law enforcement for 28 years. 25 of those have been with the City of Atlanta.
Thank you, Mr. Merritt. Mr. LoRusso?
Thank you. Could you tell us your role at the City of Atlanta and whether or not you are a post-certified instructor in the use of force and the use of a taser?
I am an instructor assigned to the Critical Incident Training Unit at our training academy, and I am a post-certified instructor, both general as well as in a variety of other things, one of them being the taser.
Have you ever been exposed to a taser?
I've been exposed to the taser 6 times.
And the term neuromuscular incapacitation with a taser, that refers to the application of electricity if it's done properly with a good deployment, and it keeps a person from moving, correct?
If you get full MMI, yes, it will. It can prevent the person from moving. Yes.
It does not prevent a person from listening to your commands, correct?
Not at all. No, it does not.
And it does prevent a person from reaching for a weapon?
If you have full NMI, yes, it can.
Are you familiar with the City of Atlanta's taser policy? It's been introduced here as A1, Exhibit A1.
I am.
And do you agree with the statement at 4.2.1? It states an officer's decision to employ the CEW taser shall involve a physical arrest or a situation where the subject is escalating from passive to active resistance. Did I read that accurately?
You did.
And do you agree also 4.2.2 that the City of Atlanta Training Department teaches a CEW deployment is to prevent further escalation of a situation and to minimize injury to the officer, the suspect, or a third party, correct?
Correct.
So the taser, would you agree, is a de-escalation tool used by an officer to keep physical force from escalating or to keep someone from accessing a weapon such as a firearm?
That is correct.
And that is what is taught by the City of Atlanta Police Department Training Unit, correct?
Specifically, yes, in the training. That de-escalation, using it as a de-escalation tool is specifically covered, yes.
And you've seen the videos of the arrest of Messiah Young and Tanaya Pilgrim on May 31st, 2020?
I have.
And did you see any violation of Atlanta Police Department policy?
No.
Did you see any violations of state law?
No.
And specifically, in your role as a trainer with the City of Atlanta Police Department Training Unit, did you see any violation of 4.2.5 maltreatment or unnecessary force?
No,
Did you see any violations of maltreatment, unnecessary force by any of the officers surrounding the vehicle when Messiah Young and Tanaya Pilgrim were arrested?
no,
And you were there, weren't you?
I was there.
That's all the questions I have right now, sir.
Ms. Hardy, Cross?
Yes, thank you. Senior Officer Merritt, I understand you have an opinion about what happened to Mr. Gardner and his termination, but you were not authorized to decide whether or not to terminate Mr. Gardner. Is that correct?
That is correct.
At the end of the day, the chief is the one who makes that decision. Is that correct?
That is correct.
I know that you are a highly respected trainer and you have familiarity with de-escalation, correct?
Correct.
And de-escalation includes slowing a situation down, correct?
If the situation allows, that is part of it, yes.
And,
If circumstances allow you to slow it down, yes.
and that's particularly important where there's not an immediate threat. Is that correct?
If you have the ability to that is one of the factors that is taken into consideration. If the situation allows you to slow it down, yes, it's immediacy of threat.
So yes, I am correct. Just want to make
Yeah.
sure.
Yeah, if allowable.
Okay. And understanding de-escalation techniques requires training and expertise, correct?
I'm sorry, could you restate that?
Understanding de-escalation techniques requires training, expertise, experience, correct?
Expertise does benefit, but yes.
And that's in fact, you have spent a lot of hours training other officers in de-escalation, correct?
It is one of the things that we do cover, yes.
Something you covered, that you've been a subject matter.
In the training that we do, yes, that is one of the things that is covered.
And Mr. Gardner would have had that training in his background, is that correct?
I do believe everyone had to go through the state provided training.
Okay, let's pull it up. I won't make you guess. I'd like to look at Mr. Gardner's training record, please. Let's show it to Senior Officer Merritt so he doesn't have to assume. Mr. Merritt, we have the post-training record available for you to see. Is that the official record of the training that Mr. Gardner would have had?
It is coming up right now. That is his post record right there. Yes, that all officers have if you go to the post website.
Okay, great. And would this be the official record?
Yes, if you pull up anybody's training history, this is the format that it comes out in.
Okay, we can rely on this document.
Yes.
Okay. And I see that his last three training courses were cultural awareness, use of force, and de-escalation options for gaining compliance. Is that correct?
Yes, those are all courses that are provided by the State Police Academy that were done in an online format, but all officers who do take those trainings, yes.
And so you would assume that given these trainings in spring of 2020, Mr. Gardner would have training and experience on de-escalation. Is that correct?
He would, per this training record, he would have attended the state-provided online training in de-escalation.
Okay, thank you. I have no further questions.
Mr. LoRusso, redirect.
Yes, sir. Officer Merritt, if a person takes training as a TFO from federal agencies that they're assigned to, that training may not show up on their post records, correct?
That's correct.
That's all the questions I have.
Ms. Hardy, any further questions?
Nothing further, Mr. Hawkins.
Panel officers, any questions?
No, thank you, Mr. Chair.
Hearing none, Mr. Merritt, you are free to go. We would ask that you not discuss your testimony with anyone outside of this hearing.
Thank you.
Thank you. Mr. LoRusso, please call your next witness.
Next witness would be Captain Brian Schiefbauer. Actually, the witness after that, Ms. Harmon, will be Sergeant William Dean. So Schiefbauer now, and then Ms. Harmon be Sergeant William Dean after that.
Okay.
while we are waiting for them to connect, let me just mention to the city, you have used 72 minutes of your 90 minutes, and the appellant has used 33 minutes of their 90 minutes.
Thank you, Mr. Alameen.
Thank you, sir. Major Schiefbauer?
Yes.
Okay, want to make sure you could hear us. Mr. Hawkins, I believe he's
Chief
ready.
Bauer, can you hear us okay?
Sir.
I can barely hear you.
Can you hear me now?
That's better.
Okay.
Hello, sir. Do you have any objection to taking an oath?
Oh, no, sir.
Would you please raise your right hand? Do you swear or affirm to tell the truth?
I do.
And for the record, would you please state your name, your job title, and years of service with the city?
Major Brian Schiffbauer, City of Atlanta Police Department, Code Enforcement Division. I've been on just over 21 years.
Thank you. Mr. LoRusso.
Major Schiefbauer, at the time of these events, May 31st, 2020, you were a captain, correct?
That's correct.
And you're familiar with investigators Gardner and Streeter?
I am.
And you spoke with investigator Gardner following the May 31st arrest of Tanaya Pilgrim and Messiah Young?
Yes.
And are you aware that they were instructed that they could wait until the next day to turn in their use of force and incident reports?
I do not recall that.
Not be uncommon for that to happen after somebody worked an extended shift, would it?
According to SOP, reports are supposed to be completed before the end of the shift.
It's not uncommon after an extended shift for someone to be given a dispensation to do it the next day, correct?
I wouldn't say that.
So you had an opportunity in your role as a captain over Investigator Gardner to review the videos and the incident reports concerning the arrest of Tanaya Pilgrim, correct?
That's correct.
And you saw that they were placed under arrest for the curfew, among other things, correct?
That's correct.
And also for refusing instructions?
Yes, that's correct.
So you, as a supervisor with the City of Atlanta Police Department, understand that if you witness a violation of an excessive force by an officer, you're required to report that to Internal Affairs or OPS, correct?
That is correct.
And you did not make such a report following your review of the videos, did you?
Based on my review of the videos, that is correct.
And Exhibit 20 that we have up is an email that you sent to Stacy Gibbs and Fred Watson. Can you tell us who that is? Who that is, both those people?
Deputy Chief Stacy Gibbs, she was the division commander at the time, and Major Fred Watson was the commander of the Special Enforcement Section.
And when you reviewed the videos, you did not see any violation of state law in the arrest of Tanaya Pilgrim, did you?
Based on my review of the videos, I did not.
And you didn't see any violations of any work rule, including a violation of excessive force by Investigator Gardner, did you?
Based on my brief investigation, I did not.
That's all I have at this time. I may have some recross.
Cross, Ms. Hardy.
Redirect, excuse me.
Thank you, Major. How long did you spend reviewing? You said it was brief, your brief review of the footage. How long did you spend reviewing the footage?
Maybe an hour.
Total?
And it was a matter of trying to find the video, go through the video, and try to watch as much of the video as I could.
Okay. How many times did you watch the video?
There was several different officers' video that I watched that night. Once or twice, maybe for each individual body cam that I viewed, that just tried to get all the details. Everything was happening fast, a lot of chaos, a lot of commotion, just trying to make sure that I was getting the detailed right information.
And in viewing the footage, you did not actually observe any weapon in the car. Is that correct?
That is correct.
Neither Miss Pilgrim nor Mr. Young had a weapon, correct?
Not that I saw.
And no weapon was ever recovered from the car, is that correct?
To the best of my knowledge, I do not believe one was recovered, but I don't have the totality of the circumstances.
Okay. And who has the ultimate responsibility and obligation to assess the totality of the circumstances and make a determination on what discipline is appropriate?
It would be the appointed police chief of the organization.
And in this situation, was that Chief Erica Shields?
Yes, ma'am, it was.
Okay. Thank you, Major. I appreciate your time.
Yes,
No
ma'am.
further questions, Mr. Chair.
Redirect Mr. LoRusso.
Nothing further for this witness. Next witness up will be Sergeant Dean, and on deck will be Jamie Borden.
Panel officers, do you have any questions for Major Schiffbauer?
No, I don't.
No, thank you, Major.
Major, thank you very much for your testimony. You're free to go. We ask that you please not discuss or share any of your testimony with anyone outside of this hearing.
Yes, sir. Thank you very much.
Thank you. Please call the next witness.
Sergeant William Dean, and next up will be Jamie Borden. I believe he's connecting to audio right now, Mr. Hawkins, but I believe we have his picture there.
Okay, I don't have his pictures yet.
Sergeant Dean, you're on mute. You're on mute.
Off now. There we go.
Thank you.
Sergeant Dean, do you have any objection to taking an oath, sir?
No, I don't.
Would you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, I do.
Would you please state your name for the record, job title, and years of service with the city?
Sergeant William Dean. I'm currently assigned to Internal Affairs. I've been with the city of Atlanta for 28 years.
Thank you, Mr. LoRusso.
Sergeant Dean, good morning. How long have you been with Internal Affairs?
Since 2006, so roughly 14, 15 years.
And have you attended investigations regarding use of force and allegations of excessive force by officers of the City of Atlanta Police Department?
Yes.
And have you received training in doing so?
Yes.
And are you aware of the policies that require an investigation into the use of force by the OPS or Internal Affairs Unit?
Yes, I am.
Are you aware of a priority 1 complaint being a complaint which is of a serious nature that an employee's conduct has resulted where there's an unauthorized use of force? Is that correct in 5.2.6?
That's correct.
And are you aware that priority 1 complaints must, according to City of Atlanta policy, be investigated by the Office of Professional Standards?
Yes, I am. That's correct.
Are you also aware that violations of an improper use, work rule violations arising out of the use of a CEW or a taser also require intervention by the City of Atlanta?
Yes.
And can you tell us whether or not an investigation was done by OPS regarding the arrest of Tanaya Pilgrim and the actions by investigator Mark Gardner prior to his termination on May 31st, 2020?
No, an investigation was not conducted.
And have you ever participated in the termination of an employee such that you're familiar with the policies, procedures, and ordinances that must be followed prior to termination?
That's correct. Yes.
Do the ordinances require that a delay between the notice of proposed adverse action and the notice of final adverse action?
That's the policy. I have seen emergency hearings where the notice of proposed was issued and the notice of final was the very next day.
And in this situation, you also serve as the advocacy officer, and I may be using the incorrect term.
That's correct. I work in advocacy now.
So the advocacy officer essentially is there to ensure that policies, procedures, ordinances are followed when the City of Atlanta metes out discipline, correct?
That's correct. We also make sure that the recommended or proposed discipline is within the range that's established by previous cases or
Now,
investigations.
Thank you. Is it fair to say that during the termination of Investigator Mark Gardner, the policies, procedures, and ordinances and normal policies were not followed?
That's correct.
And as an advocacy officer, you were not called to the chief's office when the notice of proposed adverse action or notice of final adverse action were provided to Investigator Gardner, correct?
That's correct.
And there was no recording done of any personal response that Investigator Gardner would have given, correct?
That's correct.
Have you had an opportunity to review the notice of proposed adverse action and the notice of final adverse action?
In regards to
Investigator Gardner.
Yes,
And there is no notation of any circumstances that justify an emergency action, is there?
not to my knowledge, no.
And in fact, on the notice of final adverse action, the box for emergency action is checked no, is it not?
Yes,
It should be checked yes if it was an emergency action, should it not?
that's correct.
Now, if an employee gives a personal response to an emergency action, excuse me, a notice of final adverse action, some sort of summary is supposed to be noted, as we see on the, this is A17, notice of final adverse action at the top third. Is that correct?
Yes, you would write out a short summary of what the employee's response was.
And if the employee doesn't give a response, you don't check the box that they did, do you?
No,
It would be completely improper and in some ways dishonest to check that somebody had given a personal response if they didn't do so, right?
well, the personal response, sometimes employees will respond personally, but they actually won't do any of the conversation or talking. It'll usually be a union rep, or I've had situations where they didn't want to say anything.
Okay, let's talk about that situation where the union rep doesn't say anything, their lawyer doesn't say anything, and the employee doesn't say anything. Then they have not given a personal response, have they?
No,
And it would be incorrect and intellectually dishonest to place a checkbox that they gave a personal response, wouldn't it?
that's correct.
Now, there was an investigation done into the actions of Investigator Willie Sauls, who was on the scene at the arrest of Tanaya Pilgrim and Messiah Young. Was there not?
Yes,
And he was cleared of any wrongdoing and excessive force charges, correct?
that's correct.
That's all I have at this time. I may have some redirect.
Cross, Ms. Hardy?
Yes, thank you, Mr. Chair. Sergeant Dean, you do not have the authority to decide whether Mr. Gardner should be terminated, correct?
I'm sorry, I can barely hear you. Can you repeat that?
Yes, absolutely. You are not the one who has the authority to determine whether Mr. Gardner should be terminated. Is that correct?
That's correct.
And that obligation and responsibility sits with the chief of police, correct?
Correct.
And in May of 2020, that was Chief Erica Shields. Is that correct?
Correct.
Thank you. No further questions for this witness. Thank you, Sergeant Dean.
Mr. LoRusso?
Did you have any conversations with anyone raising a red flag as the advocacy officer that the procedures, policies, procedures, and ordinances were not being followed regarding the termination of Investigator Mark Gardner?
I had conversations with my immediate supervisor as to the rush, and we were kind of deviating from the way we normally do the process.
And the City of Atlanta policies and procedures have the ability, and the ordinances allow an employee to be sidelined, if you will, suspended either without pay or with pay pending an investigation, do they not?
Typically, since I've been in internal affairs, I've only seen one employee fired at an emergency hearing. The others were suspended without pay or with pay.
And waiting for OPS to do an investigation into something like excessive force, correct?
Either that or court dispositions, but yeah, the investigation would have to be conducted.
Did anyone tell you the reason why this Investigator Gardner was terminated so quickly?
Not directly. I was basically told to hurry up and send the paperwork to the chief's office. It had to be done before the press conference.
So you were told that the termination of investigator Mark Gardner had to be done before the press conference, right?
Correct.
That's all the questions I have.
Ms. Hardy?
Sergeant Dean, you are aware that the chief of police determined that Mr. Gardner's termination was an emergency under the city code. Is that correct?
Yes,
And the chief is not obligated to disclose to you why she made that determination. Is that correct?
that's correct.
Okay, thank you.
Mr. LoRusso, any further questions?
Not from this witness. My next witness would be Jamie Borden.
Okay. Panel officers, do you have any questions for Sergeant Dean?
Yeah, Sergeant Dean, I did have one. So if in a case where the NPAA has emergency and the NFAA does not check emergency, is that unusual? How do you regard that?
That's unusual. That's a typo.
Okay,
Those forms are usually prepared by myself or someone in my office, but it wasn't. So it was more than likely a typo.
okay, thank you, sir.
Okay, thank you, Sergeant Dean. You are.
I do have, excuse me, Mr. Hawkins. I do
Yes.
have one question
Oh, okay,
for
sure.
Officer Dean. Without disclosing what the infraction was in the case of the officer who was dismissed immediately, that you mentioned, in your opinion, was that dismissal within the guidelines that you feel it should have been a dismissal, an emergency situation?
Yeah, to shed some light on that, the officer was arrested and charged with murder. So yes, it would apply in that case.
Okay, thank you.
All right.
Okay, Sergeant Dean, you are free to go. Thank you for your testimony, and please do not discuss your testimony with anyone outside of this hearing.
All right. You guys have a good evening.
Thank you. You have a nice day. Mr. LoRusso, please call your next witness.
Next witness will be Jamie Borden. And on deck would be, Ms. Harmon would be Investigator Gardner, but obviously he's with us. So thank you for your help.
Okay, he's there.
I can't see him.
Yeah.
We'll take
Sergeant
the
Borden.
exhibit down, Mr. Hawkins. That might help a little bit. There we go.
Yeah.
Mr. Borden,
Yes, sir.
good afternoon. Do you have any objection to taking an oath?
I do not, sir.
Would you please raise your right hand? Do you swear or affirm to tell the truth?
I do.
And for the record, would you please state your full name, your job title, and years of service with the city?
My name is James W. Borden. I'm a sergeant retired with the city of Henderson after service from 1997 through 2018.
Thank you. Mr. LoRusso, please proceed.
Sergeant Borden, good afternoon, I guess we are right now. You have done some training in the state of Georgia. You've actually trained GBI agents and other investigators in the methods and appropriate methods for investigating a use of force incident, have you not?
I have, sir. Yes, sir.
And how recent was your most recent training in that regard?
I believe I spoke at the CIPHER conference, the Society for Integrity of Force Investigations and Reporting, in early 2020, I believe. I don't have the date right in front of me. I believe it's on my CV, if I might check that.
Yes, and the CV Exhibit 38 is his curriculum vitae and Rule 26 list for the members of the panel. We would move to admit that as an exhibit. We'd also move to admit all the other exhibits just to make sure that we're crossing T's and dotting I's, Mr. Hawkins.
Okay, any objections from Ms. Hardy on that end?
We do object, Mr. Chair. If I'm just looking at the ruling that this board has already made with regard to Mr. Borden, he has a very narrow scope of testimony, and I'm not sure even what we're seeing on the screen right now with regard to this is going to be part of the alleged conduct on May 30th. So I certainly wouldn't be able to agree to a blanket stipulation.
Mr. Hawkins, may I respond?
Yes,
Sure.
I would have to agree with the city on this because we have gone over this being an administrative hearing that we will consider even hearsay. So whatever Mr. Borden, this has been already decided, whatever his testimony, it must reflect directly on what this case is about and about the city of Atlanta and our police department. So if we can't get that blended into what we're doing here, we would just weigh what Mr. Borden says and give it the weight that the board feels would be appropriate. Is that clear or making?
It is. If I could respond very quickly. These documents have to do with his qualifications as to the weight of his testimony. So I can tell you, I know none of you are members of the bar. We have the curriculum vitae and then a Rule 26 list, which is a list of cases in which he has been accepted as an expert. And lawyers are familiar that a Rule 26 list is about the most basic part of a witness's qualifications as an expert. I don't even understand why we're getting an objection about it from the city, first of all. And second, I don't understand why Ms. Lawrence Hardy's objecting because she's had a copy of this exhibit since somewhere in November. So all it is a list of cases he has been accepted in, and it goes to the weight of his testimony, which, as you stated, Ms. File, appropriately, is for you to determine. And I think it's appropriate just to understand what his background and experience is.
Okay, and it's 17 pages, so it is impressive. So, Ms. Lawrence Hardy, on you.
So we would ask that we go directly to the testimony as set forth in this board's order yesterday, which is testimony specifically about the APD's policies or procedures and the appellant's alleged conduct on May 30th or the need for discipline in this case. Everything else, I believe, has been excluded and prohibited by this board.
Nothing excluded a statement of his qualifications. That is a gross misstatement of what the order states. No witness, no expert witness is ever excluded from stating what their qualifications are, just as Mr. Hawkins asked every witness when they came up here what their qualifications were, their years with the city, and that goes to the weight of their evidence. I don't want to take time doing this, Mr. Hawkins. I can just have him testify. He has been accepted in 23 courts as an expert. And if you want me to just move forward, I will move forward.
Would you please just move forward? I think that would be appropriate. Thank you.
Sergeant Borden, in your review of the videos in this case, you also reviewed the policies and procedures of the city of Atlanta, the ordinances of the city of Atlanta, and state law regarding the use of force for law enforcement officers, did you not?
Yes, sir.
Can you tell us your comments and observations about the use of force, CEW, and other related policies and procedures of the city of Atlanta?
Yeah, I've done a fairly deep dive in the policies for Atlanta. And as I said in the previous case, these policies are probably some of the most eloquently written and most articulate policies that I've come across in my travels. And I've had cases in many states from Washington to Maine, and these policies are very well written and very thoughtful. And the ones that I've given the most merit to are SOP 310, I believe 3042 and 2020, respectively, dealing with the CEW, use of force, and then associated disciplines for any allegations of wrongdoing or maltreatment, as the statements, the documentation that I've gone through reflect the reason that the officers were fired.
Now, have you had an opportunity to review the videos as well?
Yes, I have.
And tell this board why it is important during a use of force investigation and why the City of Atlanta policies and procedures, and specifically referencing Graham versus Connor in the policies and procedures, why it is important to actually conduct an investigation and interview the officer prior to making a decision as opposed to just looking at a video.
Well, most importantly, as it relates directly to the City of Atlanta's policy, is that they in their policy, it states they will conduct an investigation to discover wrongdoing or any improvements that need to be made to the department. And that congruency is it is congruent because of the connection to Graham versus Connor, which is stated verbatim in section 5.6 in the use of force policy. It discusses Graham versus Connor and the importance of making determinations based on the officer's decision-making process and resulting actions in those scenarios, based not on hindsight, but based on a thorough investigation, which connects to the other very well articulated policies for discipline. And in the CEW policy, it states that supervisors will be responsible for conducting investigations or initiating investigations based on any allegations of wrongdoing. And I'll tell you that reviewing the video is one very small piece of evidence that is reviewed in these cases. And this is what my certifications classes cover distinctly. And with the City of Atlanta's investigative processes and the way they have this laid out in policy, as I said, is very thoughtful. So I'm perplexed as to why these investigations haven't taken place, remembering that the hindsight attribute in Graham versus Connor is extremely important, because we look at video over and over and over and over. We have the opportunity and the luxury to make determinations based on what is important to us in that video in that moment, not understanding that that may not have been the officer's focus of attention within that video as a player in the video, right? So I've seen statements where the video was viewed multiple times, and I'll boil this down to this very pointed fact, is the officers don't have the luxury to hit stop, rewind, and pause before they act on what they reasonably believe is happening before them. Now, reasonable belief, and this isn't a statement of law, this is a statement of training and policy based on the Atlanta policy, is not a standard based in accuracy. Reasonable belief of what is happening is based on the context that the officers are working in the moment that they make that decision to use force. And to conduct a full and thorough investigation of that is imperative to get to the bottom of why the officers did what they did. And you cannot do that in 24 hours. It's impossible to do it. You cannot do that by simply looking at a video. There's too much at stake with the officers' careers, with the lives that they live, their commitment to the City of Atlanta, and the way the policies have been constructed to protect that is absolutely the most articulate thing I've ever seen. And so it's important to understand that these officers have a right to a full investigation, and it is referred to in all three of these major policies.
When you looked at the investigation and you looked at the videos, I want to ask you a hypothetical based on the policies that you looked at. If a City of Atlanta police officer operating under these policies and trained as they were trained, so far as the City of Atlanta, so far as Taser International, if they believe a person has access to a firearm in a car, would it be reasonable for them to deploy a taser to immobilize them and remove them before anyone can access that weapon?
Absolutely, 100%. That is, the use of the taser in that manner is a tool primarily used for de-escalation. Because remember that reasonable belief, it's not just a belief that the subjects have a weapon, because anybody could have a weapon, but a reasonable belief based on the officer's visual stimulus, the context in which they're working, that reasonable belief and the use of, excuse me, My apologies for that. The reasonable belief is what the officers are acting on. To use the tool, the taser, as a tool for de-escalation is a step in the right direction, because at that point, if they perceived a deadly weapon, it would have been very easy for those officers to take a step towards a higher and more lethal level of force. But I have to give commendation to the chief of police for putting it, the teams that the chief of police had on the street during this time were extremely qualified to make rapid decisions. Definitive actions, movements, and results were seen in that video from my perspective. And the simple fact that this was an arrest team that immediately went based on a reasonable belief of a deadly weapon in context with shots being fired in the background, radio traffic, assimilating that information. And they still, with all of that stimulus, they still made a decision to go to the taser to introduce force into this environment for the safety of themselves, for the safety of the occupants of that vehicle, and the safety of other individuals in the area. It was a chaotic event. By the chief's own words, it was a chaotic and unpredictable event.
Sergeant Borden, let me ask you this. There's actually two weapons at play when our investigator Gardner is approaching the car. There's the gun that we'll hear more about, but also the vehicle is a potential weapon when it is not in park and when a person has refused lawful commands to stop, is it not?
That's correct, yeah. And just to add to that, Mr. LoRusso, is that the subjects in the vehicle are the issue at hand. It's not the vehicle itself, but that's a double-edged sword. The decision-making processes and the intentions of the driver are what make that vehicle potentially a deadly weapon, and the actions of the driver and the other occupant in the vehicle are indicative, based on the context and the totality of the circumstances, and not trying to not be contrite with this, but that's really what we have to look at, is that yes, that vehicle it's a 3,500-pound weapon. If that was the choice of the driver, the issue is this, is that we don't know, police officers don't know. In hindsight, we might know that nothing happened, but police officers don't know what the intentions of those subjects are. They can only make those determinations based on what information they are extracting from that scenario in real time. And that's one of the biggest issues we have, is the officers had very pertinent reasons to do what they did, based on what they did not know, not based on what they knew, right? They have to make decisions without all the information because they don't have the luxury of hindsight, which is why Graham versus Connor forbids us from using hindsight to determine these issues.
Now, you mentioned Graham versus Connor several times, and you mentioned it's in the policies. I'm pulling this up for the board mainly, but Graham versus Connor is a opinion out of the United States Supreme Court. And I'm pulling up section 5.6 of the use of force policy. And I would move to admit this into evidence. I believe it's actually in evidence, but I would move to admit it. It states that it cites Graham versus Connor and says reasonableness in analyzing the use of force is not capable of precise definition or mechanical application. In determining whether an employee's use of force is reasonable in a particular case, it is necessary to evaluate the facts and circumstances confronting the employee at the time the force was administered. Did I read that accurately? And does that reflect Graham versus Connor?
Absolutely.
And part of that analysis, in your opinion, your training, your experience, and what you've taught officers in the state of Georgia with the GBI and other organizations, does that necessitate a conversation with the officer asking them why they used the force they used?
Yes, absolutely. And I'll conclude that with this, is that it's easy for us to know what happened. And the what happened in this incident is not what should be used as a determining factor in the result or the discipline that happens with the officers. It's easy to determine what happened, but it is not easy to determine why that happened. And we miss that in these investigations. And because we don't get to the bottom of why these decisions were made, we miss the very core of what Graham versus Connor has put on the books as the standard for these investigations. If we don't know why, and we don't give due diligence to finding out why, which the only way that we can truly do that is to conduct an in-depth interview and give the officers the opportunity to say why they did what they did. And we compare that then to all other physical and forensic evidence, including video, that's available to us in that scene.
That's all I have at this time. Mr. Hawkins, I may have some redirect depending on questions from the city.
Cross, Ms. Hardy.
Thank you, Mr. Chair. Sergeant Borden,
Yes, ma'am.
we just looked at Grand versus Connor, but this requirement of a conversation for the investigation is actually found nowhere in that case, correct?
I'm sorry, ma'am. I'm not understanding the question. Can you?
The case that you just said was fundamental to your opinion here today, that we all just looked at, does not actually require this conversation that you just testified was necessary, correct?
Is the question that excerpt from Graham versus Connor is not required for an investigation?
No, you know what? I'll give you another question.
Okay.
I think I would just ask the board to consider the case to the extent that it is relevant in this situation in its entirety and all the language. Mr. Borden, you've never been a chief of police, correct?
That's correct.
And in fact, is that your phone, sir?
I'm sorry.
Perhaps you could turn off the ringer so.
It's off. I've got too many devices, and all of them appear to be off until I get into a conversation with you. My deepest apology. Okay.
Thank you. What parts of the Atlanta City Code did you read to prepare for your testimony here today?
I've got them in front of me here. I believe primarily I looked at 17.420, the authorization to arrest. And then the Atlanta City Code was 114.530, I believe.
You looked at 530.
Yes.
And let me ask you this. In your view, when the city's SOPs and the code have a conflict or a tension, which governs?
That calls for a legal conclusion from this witness, and I would object to that.
Well, just in your experience, such as it is.
Which is the governing aspect of that investigation if it conflicts with the Atlanta Code?
Yep, didn't say anything about the investigation. Listen carefully. I'll make the question really simple. When there is a tension or conflict between SOPs for the city and the city code, in your view, which govern?
It's different for every department, but for instance, Nevada revised statute does not override policy.
Let me focus you because our time is short. In Atlanta.
Yeah. I don't know which is the governing. I'm not sure. I've not had experience with that.
Okay. Are you familiar with the Atlanta City Code, section 114.526, allowing for immediate dismissal of an officer?
No, I did not look at that.
That's not one of the ones you reviewed, correct?
Correct.
And you wouldn't know, therefore, whether that code section requires or does not require an investigation prior to termination, correct?
Yeah, that's correct.
And in fact, even if it did require an investigation, you wouldn't know under the city code what the content of that investigation would need to be. Is that correct?
Well, that's going to be governed by the city's policies. The policies are in place for the officers to adhere to and for the department to adhere to based on what they state in policy and purpose to protect the integrity of the department and in the determinations of the right and wrong doings of an officer.
Move to strike is non-responsive. I just asked you of whether under 526, right, what the code requires. You told me you haven't.
I believe.
And you told me you haven't read it yet.
I have not. I'm not familiar with 526.
Okay. Are you post certified in Georgia? Let me just read it out. Are you certified by the Peace Officers Standards and Training Council in Georgia?
No, ma'am.
Okay. Ms. Pilgrim, in fact, did not have a gun, correct?
There was no gun, to my knowledge, that was known after the fact.
Is that correct? Ms. Pilgrim did not have a gun.
There was no weapon in the vehicle that I know of.
And could you see her hands when you reviewed the footage?
I could see her hands when I reviewed the footage, yes.
Did she appear to have a gun in her hands at any time?
She did not, to me.
And Miss Pilgrim wasn't driving a car, correct?
That's correct.
At no time was she in control of the car. Is that correct?
Based on the video, that's correct.
Okay. And you referenced earlier that this determination of a termination needed to be made based on the facts and circumstances of the situation. You talked about the facts and circumstances that needed to be weighed. Under the city code, who has the obligation and responsibility to weigh and evaluate those facts and circumstances to determine the appropriate discipline?
First of all, the facts and circumstances have to be discovered.
Listen to my question. Maybe I'll ask it a different way to make it simpler. Under the city code of Atlanta, the
Which
chief
code
of
is that?
police,
Which code?
all of it, the entire, any city code provision that is relevant to this situation,
Okay.
under any provision that is relevant, isn't it true that Chief Erica Shields is the one who has the ultimate decision-making authority, or at least did on May 30th and May 31st, 2020?
She is the chief of police. That's correct. She has ultimate authority.
And obligation and responsibility, correct?
To what? Obligation and responsibility to what?
She is the appointing authority under the code. Is that correct? Or do you know?
She is the appointing authority, yes.
Okay, thank you. No further questions.
Mr. LoRusso?
Just very briefly on a redirect. Sergeant Borden, if you are doing an investigation and you are training officers to do investigations and you are trying to determine if you have a problem with culture, if you have a problem with policy, the way they're written, if you have a problem with training, is it incumbent upon you to do a full investigation to better the department?
That's the only way you're going to be able to better the department, is to know the inner workings of what the issue is. Yes, an investigation is required.
That's all I have for this witness.
Recross, Ms. Hardy?
No, thank you, Mr. Chair. I'm finished with this witness.
Any questions from the panel officers? Hearing
No,
none.
not for me. Not for me.
No questions.
Sergeant Borden, thank you for your testimony. You're free to go. We ask that you not discuss any portion of your testimony with anyone outside of this hearing.
Thank you, sir.
Thank you.
I have a quick question. Oh, not for the, this 5.2, the APD SOP, that, is that in one of the exhibits that we can make sure that it's in, down for the record? Mr. LoRusso, you had mentioned that you were hoping that it would be included in the record.
Yes, it should be in the work rules, I believe.
Okay.
And also the use of force policy that we put in. Hang on, I'll get you it's Exhibit 3. I believe we've discussed it several different times.
It's Exhibit 3, use of
Yes,
force,
Exhibit
SOP
3.
So this 5.6 is in, is that information is in that exhibit? Okay.
Yes,
Thank
and
you.
I can even make it easier for you on page 6 of 7, Ms. File.
Okay. I
And
just want to make sure I had.
And just to make sure, Mr. Hawkins, I would like to make sure that that has been entered into evidence.
Any objections from the city?
None, Your Honor. Mr. Chair.
So noted.
The next witness would be Investigator Mark Gardner, the appellant.
So as, before we swear him in, let me mention, so the city is at 81 minutes. The appellant is at 61 minutes. So Ms. Lawrence Gardner, if you want me to let you, if you tell me how much, in terms of your closing, if you tell me how much time so we can save for your closing, I'll let you know when you run over that time. If that's.
Thank you,
if
Mr.
that's-
I
so-
appreciate the offer. My team is all over. They are recording every second, and they will be flagging me furiously when I get to about 5 minutes out. So I appreciate any reminders, but I think we should be all set on my end.
Okay, well, you're at 81 and the appellant is at 61. And so I'm not gonna and the other time that we had for the arrest and the getting people up online, we took that as a board. So for the board members, we're going to go beyond 1 o'clock because of those times that we took. But we were not going to go over the 3 hours that we provide for the hearing. Okay. All right.
Mr. LoRusso?
We are ready for Investigator Gardner, the appellant.
Mr. Gardner?
I'm here, sir.
Okay. Good afternoon. Do you have any objections to taking an oath?
I do not, sir.
Please raise your right hand. Do you swear or affirm to tell the truth?
I do.
Please state your name for the record, job title, and years of service with the city.
Mark A. Gardner, City of Atlanta Police Detective, and I've been with the city 23 years.
Thank you. Mr. LoRusso?
Good afternoon. I know that we're going to try to keep things moving, Investigator Gardner, but this is your hearing. Can you tell us how many years you've worked with the city and in what capacities you have worked? Just a brief overview.
I started with the City of Atlanta in 1997. I was sworn in March of 1998. I went to patrol Southeast Atlanta, which includes Turner Field, that area, Zone 3. I did that up until 2001, roughly around September 11th, when I went to the plainclothes unit called the Fit Team. Upon working plainclothes in Southeast Atlanta, I was promoted to detective. Was a detective for 2 or 3 years, primarily investigating robberies, burglaries, thefts in Southeast Atlanta. Then I was chosen to go to the fugitive unit roughly in 2007, I believe.
And tell us what the fugitive unit does.
So the fugitive unit is a unit that we're primarily responsible for finding, locating, apprehending some of the worst criminals in the city of Atlanta. And we partner with other law enforcement agencies in the state and around the country, actually. So if there's an individual that's wanted from Detroit and they have information that he's here in Atlanta, we will work with our local partners and our federal partners and the partners in law enforcement from that state to quickly apprehend the individual. So we work with departments throughout the country, and it's for the most serious and violent criminals: murder, homicides, bank robbers, rapists, child molesters, things of that sort.
Can you give an example of your work so far as your work as a task force officer or TFO with the FBI? How did you get selected for that, and how did you come to do that for 10 years?
Well, that's a position that when your supervisor, whoever was supervising you at the time, that's a position that they'll select you for. And the FBI has to have the need, and APD and the FBI had a nexus. So the FBI will then vet you through. You have to go through all the background investigations that a special agent with the FBI will have to go through. You have to go through an OPS investigation to ensure that you don't have any use of force complaints, any open complaints. The FBI will send out a background investigator, and they will come and ensure that there's no complaints that are pending against you. Once you're selected, then you work closely with the FBI on a day-to-day basis. And that's what I did for roughly 10 years. I was assigned to a violent crime task force here in Atlanta with the FBI, and I worked closely with them on a day-to-day basis, not only working with them, but training with them and having the opportunity to take a lot of good training and also work a lot of high-profile cases.
Did you take use of force training, including taser training and deadly force training through the FBI in your work for 10 years on the task force?
I absolutely did, yes.
Was that training run by FBI national instructors from Quantico?
Yes, actually, FBI elite SWAT team came down from Quantico, and they put on a 2-week class that we took in Gwinnett. And we went through the 2-week class with them, and we dealt with a lot of use of force, vehicle takedowns, arresting people that are armed, fugitive investigations. It was a deep class.
Did you have periodic training with the FBI that necessarily would not appear on your Georgia Post record?
Absolutely. We trained with them constantly. Numerous days we would train per month and throughout the year.
Now, prior to this incident, you took TASER training 90 days prior to the incident on May 31st, 2020?
That's correct.
And you successfully completed that training, correct?
I did.
And about 60 days prior, you took de-escalation training and successfully completed that training, correct?
Yes, I did.
Now, you work with the fugitive unit. The fugitive unit trains pretty often. It looks like from your post records, that's Exhibit 36, it's already in evidence, that in 2020, you took 24 hours of training with this team you were with on May 31st, 2020, correct?
That's correct.
Now, I have represented to the board that of 20 years of evaluations, you have 15 years at highly effective and 5 at outstanding. Is that accurate?
Yes, sir.
Now, the officers surrounding the vehicle that Tanaya Pilgrim and Messiah Young were involved in, were occupying on May 31st, 2020, is it fair to state that the experience level of those officers is approximately 120 years of experience?
That's fair to say, yes.
And those officers also are highly trained, as are you?
Yes, sir.
Now, looking at Exhibit A3, I'm going to have it pulled up here real quickly. I just want you to look at something. You're familiar with the City of Atlanta policies and procedures?
I am.
And you're familiar with the use of force policy, APD SOP 3010?
Yes.
Now, we asked for the open records for this, and we received one that was dated and signed 6/7 of 2020. Go to the top. 6/7 of 2020 on page 1. If you can, do you see that date?
I do, sir.
Now, on every policy in Atlanta, you're familiar with a notation if there's any significant changes that are made, correct?
Correct.
Now, please go to page 7 of that, and the board will note on page 8, are there any significant changes noted that have anything to do with the use of a taser, the investigation of the use of force, or anything involving your actions on May 31st, 2020?
I don't see anything.
Okay. They relate the change for the changes related to chokeholds. There are no chokeholds employed, contemplated, or used at any time during this event on May 31st, 2020, were there?
No, there was not.
Are you college? You have a college degree, sir?
I do, sir.
And you have a daughter in college now?
I do, sir. Yes.
And what age was she on May 31st, 2020?
She would have been 22.
So approximately the same age as as Tanaya Pilgrim?
That's correct.
Now, when you went to, let's just talk about the time involving these riots. What type of shifts were you working May 30th and May 31st, 2020? Tell us what you were doing for the city and how you were dressed when you were doing it.
On the Friday? On
the Friday, Saturday, that whole time.
So on May 30th, we came in at 8 a.m. that morning, which would have been our regular shift. And we would have gotten off at 4 p.m. However, the potential for the protesters and possibly rioters was present. So at 4 p.m., which would have been my 8-hour regular shift, I would have went home, but they told us to remain standby and be prepared. And we did. And we continued working from 8 a.m. that morning up until roughly 4 a.m. the next morning before we went home.
So fair to state that you came in and worked for 20 hours straight?
Absolutely, yes, correct.
And were you ready to come back in, suit up, put your uniform on, and come back to work for the city the next time you were called in?
Oh, absolutely.
And were you called in again?
We were.
I would like you to take a brief moment and tell the board how you were dressed when you were working and what it was like to be in your skin and in your City of Atlanta police uniform on the streets of the City of Atlanta on May 30th, May 29th and May 30th, and May 31st, 2020.
Well, we were wearing, we generally dress down. We don't wear a police uniform, but when we do go out to make arrests, we'll have police attire on, a vest that's clearly marking of who we are, Atlanta Police, with our name and things of that sort on it. So once we went on the streets, that's what we had on. We call it our BDU gear. I believe it was green pants, black shirt, and our city issued marked vest. We also had head protection on and ear protection.
Can you tell the board why you were issued and told to wear hearing protection and a Kevlar helmet while you were walking around the streets of the city of Atlanta for 2 nights?
Well, we were told, and we actually witnessed it firsthand, but we were told that there was going to be a potential for violence against police officers. This was the climate that was going on throughout the country. I think that we weren't prepared from the upper echelon. We weren't prepared for it, to be quite honest, but we were. The soldiers on the ground, us that was out there doing the job, we had mentally prepared ourselves for the night that was going to come. And we were told to, before we left the office, because we were sitting in the office at 4 p.m., and we were told by our immediate supervisors to grab all your gear and be prepared for a long night.
Were there any threats of violence, gunfire, or bombs going off around you?
That night, absolutely. The first night, yes. The protesters quickly went from protesters to rioters. Very quick, before it got dark on the first night, which I believe would have been the 30th. Before it got dark, I'm sure everyone's seen the news footage. Before it was dark, they were burning police cars. They had almost taken over CNN building, College Hall of Fame. They were burning civilian cars. They were damaging businesses in the downtown Marietta, COP, Centennial Olympic Park area, that corridor. So it was very hostile, very dangerous, and we were in the mix of it.
How often did you hear gunfire?
Oh, too numerous to put a number to. It was constant. It was. I'm sorry. It was constant gunfire. It was constant being assaulted, bricks being thrown. We went through that, I would say, easily with no rest, easily from 5:30 till at least 1 a.m. in the morning before we actually was able to regroup and sit down. When I say 5:30 to 1 a.m., this is constant moving and trying to protect ourselves, trying to protect the CNN building. They took our team and took us to the CNN to hold the CNN building because their fear was that the protesters which became rioters had already breached the CNN building. And the CNN, although they have their own police department, they were in no way able to protect the CNN building. So we had to hold the CNN building for hours while they just threw anything that they can to. They had already, now mind you, they had already taken it over. The glass of the CNN building was broken, it was shattered. So all they needed to do was enter. And there were other businesses in that same corridor that was being damaged. So again, that probably went from 5:30 p.m. to 1:30 a.m. in the morning before we actually had a break.
Were y'all scared?
Mr. Gardner?
Yes, yeah. As a police officer, it's hard to say I was, but yeah, I was.
Did you ever think
it was a frightening scenario.
Investigator Gardner, did you ever think of looking at your supervisor and looking at the people around you and saying, I'm done, throwing your hands up and going back to your car and driving home?
Absolutely not.
Did you come back to work the next day?
I did. I have full faith in my supervisor, my immediate supervisors, and my team, and we owed it to each other. And this is a city that I've worked for 23 years, that I absolutely love my job. And it hurt me to my core to see what was going on in the city that night. And it hurt me more so that the leadership at the time was not how can I put it, was not prepared.
me
Because
ask
this
you a
was going
question.
on around, I'm
When
sorry.
people were being arrested by the city of Atlanta officers like you, and they were brought to a holding cell to be processed, are you aware of whether or not they were being released immediately if they didn't have any identification?
I am aware of that. I was advised of that the night of the 31st, yes.
So you guys were arresting people. They were going to a city of Atlanta developed by Chief Shields. Part of her program was to bring them to a holding area. And if they didn't have ID, they were just being allowed to walk away. Is that true?
That's absolutely correct. And I could testify to that because I witnessed it myself. Person on my team we had arrested someone with a gun. And the person was arrested, detained. He was taken to the processing area, which was right outside of CNN. It was a sterile area. This was the area that they had designated to bring people that were under arrest. And we had taken him to this area, secured the gun, turned the gun into an area that was called property area, that they was keeping the arrestees' property. And shortly after that, the subject was again walking down the street 30, 40 minutes later. So my partner and I was astonished, and we actually went back to the guy and we said, "How did you get released?" And he said, "They let me go." So we took him back to the processing area and we questioned the process. And we were told then that if a person did not have identification on their person, that Major Villaroa, who was in charge of the processing area, was letting them go, releasing them with no charges, just because they didn't have ID. That was a thing to me that was a leadership thing. Major Villaroa is a part of the command staff. When I tell you that this entire incident was just not done properly, starting from the top, it was astonishing to me. I've worked Super Bowls.
Let me call your attention to May 31st, 2020. When you approached the car with Tonight Pilgrim, and you know that we're going to get short on time here. So these videos have been all over the news. They've been national news. You have seen this conversation take place and this hearing take place, and you witnessed the hearing of Investigator Streeter too a couple of weeks ago. People on this call want to know why. I want you to tell them, why did you deploy a taser on Tanaya Pilgrim?
I deployed a taser on Tanaya Pilgrim, a female passenger in that car who is the same age as my college daughter. I deployed the taser on her because we were in fear of our life. We were told, I heard gun. I know there's some discrepancies about the video that Ms. Lawrence Hardy provided, but I know that when I approached that car, there was an officer to my right who was not an APD officer. There was officers, again, that was helping us, assisting us that night because of just how chaotic this was. But there was an officer that said, they got a gun. They got a gun. And I knew at that point that I had an obligation, a duty to my team and to the female passenger to de-escalate that situation. That's been my training. That's been my experience. I've done this numerous times, and I know what the taser does. And I knew that the taser would give us the opportunity to, if deployed correctly, will give us the opportunity to de-escalate that situation and allow us to then remove her from the car, him from the car, and let's now figure out if there's a gun in this car. But I know that when I approached that car that I heard gun.
Now, when you said that you heard gun, you said there was an officer to your right who was not an Atlanta police officer. Have you had situations where you're close to officers with all the equipment you have where you can hear something close to you, but it's not necessarily picked up on the body camera? Have you experienced that personally before?
Oh, absolutely. We wear I'll say air protection, for lack of a better word, but we wear air protection, helmets, we have our radios on, and I've been in close stacks, maybe 2 or 3 in a stack, and someone that could be either right in front of you or 2 people behind you in a stack may say something, and I may not hear it or someone else may not hear it. The reason we know that, because when we do any operation, we debrief. And after we debrief, someone may say, hey, did you hear me say gun? Or did you hear me say, suspects hiding over there to the right? And the other person may say, no, I didn't hear that. But that's the reason we debrief, because we know that there's threats that we may have missed because of whatever reason.
Okay, I want to be very clear here. Did you believe, and were you told by the officer to your side, who was not an Atlanta police officer, that there was a gun in that car before you deployed the taser?
Absolutely, yes.
Now, what efforts did you go to try to find the gun that you believed was in that car that from which you pulled Tanaya Pilgrim?
I went back to this so-called processing area, which the property was. So if you were being arrested and you had property that couldn't go to the jail with you, they had a truck. They brought a truck out and they was taking the person's properties, purses, guns, any type of contraband or whatever. They was placing it into this truck. I went to the officer that was manning that position, and I asked him, I said, do you have a gun that was possibly turned in with either an unknown subject, because at that time I did not know the female passenger's name, but I said, do you have a gun possibly that may be in your possession that you don't have a name with? And he said, Gardner, no. He said, I have 7 guns, but each gun is accounted for with a body.
What else did you do to try to account for the gun that you believed was in the car?
We went back to the car and we searched the car. We looked through the car. We looked through the immediate area, because I've worked cases where someone may throw a gun out a window on a police chase. And if you go back and you look, 9 times out of 10, you can find it. But we looked under the seats of the car, in between the consoles of the car, in the immediate area of the car. And again, I went to the processing area and I tried to locate this gun.
Do you know if anyone from your team searched the car the next day to see if there was a gun in the car that you all believe was there?
I do believe I was told that they did go and search the car, yes.
Now, there's been much question about whether or not statements were made and orders were given to Tanaya Pilgrim. When the orders were being given by one person in the video, telling her to open the door and to get out, was that you giving those orders?
That was not me.
Okay, so who was giving those orders?
I'm not sure. I can't say for certain. I know who was on the side with me. I know it was Sergeant Lonnie Hood. And there were some other officers, I believe Claude, but I can't say for certain.
Now, when you hear in your training, when somebody is giving loud, clear commands, can you tell the board whether or not you're trained to be quiet to avoid confusion?
Absolutely. We train for that, even if we're going into a door. As we train, like to go into a house, to go for a fugitive, we always remind the entry team that only one person should talk. Sometimes we have to deviate from that because a second person may see something, but we want to limit the amount of communication, the verbal communication. We could do the pointing and things of that sort, but the verbal communication we want to limit as to not to confuse not only the team, the entry team, but the subject or suspect that we're trying to apprehend.
Okay, and as you know that we're kind of short on time, I want to be very, very specific. You heard the chief's description of the presentation of the notice of proposed adverse action and the presentation of the notice of final adverse action. Did you want to provide a personal response to the chief?
Yes, I did. Absolutely.
Did you have
an
opportunity to provide a personal response to Chief Shields prior to being terminated?
Absolutely did not.
Now, Chief Shields told a story of how this unfolded. Is her account accurate by any means?
No, it's not.
Were you sitting with anyone when Chief Shields came in the final time to talk to you?
I was sitting with the union's attorney.
Now, when she provided the notice of proposed adverse action, you asked her to wait about 20 minutes, correct?
That's correct.
And is it your understanding in 23 years and with the City of Atlanta Police Department that you have a right to have an attorney or a union lawyer there before you make a personal response?
Absolutely. That's always been communicated to us.
But
Absolutely.
you didn't have an opportunity to do that because when Chief Shields came back in, she saw you and your lawyer there, didn't give you an opportunity and told you were fired. Isn't that correct?
That's correct.
That's all I have at this time.
Cross, Ms. Hardy.
Yes, may I just get a time check to make sure our records are the same as yours?
Mr. Elamine?
Sorry, I was mute. Mr. LoRusso has 4 minutes left, and you have 9 minutes left.
Thank you, Mr. Elamine. Mr. Gardner, please take a look at City 01. I'm sorry, not City 01. I'd like to look at City, I'm sorry. I'd like to look at A3. Mr. Gansky, if you'll put up A3, please, for Mr. Gardner. We looked at this earlier. Ms. Fowle asked about it. Just want to make sure that we're clear. This is A3, which is Rule 30.10. Is that correct, Mr. Gardner?
Yes.
And you were not terminated for violating this rule, correct?
This is the use of force.
Were you terminated? What rule were you terminated for violating?
40-2-50.
Okay, so 30.10 has no relevance to your testimony today. Is that correct?
Objection. He's already testified about a section of the policy. Clearly, it's relevant now.
Thank you, Ms. LoRusso. I'm going to ask Mr. Gardner, were you terminated for any violation of this rule, 30.10?
The termination on the NFAA says 40-2-50. I don't know if I can appropriately answer that question, but
okay. Thank you. And if you'll recall, we watched earlier video today, and I'm sure you've taken a look at all of the footage. Is there any video footage of which you are aware where anyone viewing that footage would hear you tell Ms. Pilgrim to show her hands before you tased her?
I'm sorry, can you ask that question again?
Are you aware of any video footage anywhere where we could hear you tell Ms. Pilgrim to show her hands before you deployed your taser against her?
I did not say, but I did hear officers say, let me see your hands. So what we train, can I finish, please? So what we train is if one officer says it, then it's included in the officers that are present. Okay. So I heard officers give her commands to say, let me see your hands, put your hands up. And she immediately said no. She said no. So that's how we train. And I'm sorry.
Go ahead. I'm sorry. It's just, lawyers can't stand racing against the clock. Please, I don't mean to interrupt you.
Okay, well, that's my response to that. If I did not say it, if an officer says it, it's as if I said it, because now I'm reacting to what the officer says. If the officer says, let me see your hands, put up your hands, and she immediately says no, that's obstruction. That's hindering our duties. So that's the best way I can answer that.
Thank you. And just so I'm clear and the record is clear, you never told Ms. Pilgrim to show her hands, correct?
I may not have.
You don't believe you did, correct?
Again, if an officer that I'm working with closely says, I'm sorry?
I'm asking you something different. Do you have
Can
any
you stop interrupting the witness, please?
That you, out of your mouth, told Ms. Pilgrim to show her hands?
I can't say that I did, and I can't say that I didn't.
Okay. I
can't say that if an officer says, let me see your hands, and I'm with the officer, we work in unison, we work together. So it's just as if I said it or if he said it.
I certainly understand your answer. Thank you. To your knowledge, was any gun ever recovered from the vehicle?
Not to my knowledge, no, no, ma'am.
No further questions. Thank you, Mr. Gardner.
Thank you.
Mr. LoRusso,
Very
I
brief
think,
redirect.
it was my understanding that you had about 4 minutes left. Do you have any further questions for Mr. Gardner?
I have one very brief question. Prior to the arrest of Tanaya Pilgrim, that was after 9 p.m., do you recall an order being given over the radio by Chief Erica Shields to the effect of stop playing around and lock them up because it was after curfew?
Absolutely, absolutely. And before we were actually deployed at 9 o'clock, the SWAT vehicle's audio went out saying that, and they did it at 8:30. They said at 9 o'clock, we're going to start to enforce the curfew. So all the protesters at this point, which became rioters, were there and they heard that. A supervisor, I believe it was Captain Bruce, got on the megaphone and she said it. And then at 9 o'clock, we were given our marching orders that, according to Chief Shields, Unit 1, everyone goes to jail. That was the marching orders that was given to us. And we started to move the rioters back. And we were at 9 o'clock, we were immediately met with resistance.
And if people were moving out of the city, did you arrest them immediately or give them an opportunity to leave?
Absolutely. Everyone had an opportunity to leave.
Thank you.
Everyone had an opportunity to leave.
That's all I have, Mr. Hawkins. I'll save the rest for my closing.
Ms. Hardy?
No more questions for this witness, Mr. Chair.
Okay. Panel officers, do you have any questions?
I have a question. Officer Gardner, I have to get this vision. You were sitting in an office with a union attorney waiting for a union rep?
No, I'm sorry. So I don't know if I said one or the other, but the union attorney would have been the union rep. I'm sorry. I don't know if that's clear, but are you asking, is a union rep a peer?
No, I think there was a statement made prior that you received your NFAA when you were sitting in an office waiting to speak to Chief Shields with a union attorney. So we just wanted to get it clear. I had the understanding that you were waiting for a union rep, but you were sitting with a union attorney?
That's correct, ma'am.
Okay.
I know. I'm sorry.
No,
I know her. I was told that she's the union attorney. I've never been in trouble before, so I've never had to deal with her. When they said that the union was going to send someone to assist us in the meeting with the chief, she came in and introduced herself as the union's attorney.
And then you were still waiting for a union rep. Is that my understanding?
No,
so
ma'am.
your meeting was to be with this union attorney and with the chief.
That's correct. When we walked into the, I'm sorry.
Okay,
When we were instructed to go to the chief's office, we were in a holding area, the conference, the holding area, a waiting room. I'm sorry. And she came out and she told us that she was going to do what she was going to do. And Streeter and I asked her, can we have a few more minutes because the union attorney is parking and she's on her way up. And she said, I don't have time. But then she said, okay. And she went back. At this point, the union attorney came up. Streeter and I was sitting there in the waiting room. And she said to us, who wants to go first? And I went in with the union attorney into the conference room. And she came in and with the NFAA, she didn't sit down, and she put the NFAA on the table, slid it across to me, and said, Mark, I'm sorry it had to happen like this, and walked out. And again, I've never been in trouble, so I didn't know. And I looked at the union attorney, and I said, is this how it's done? And the union attorney said, absolutely not. She was appalled. She said, this is not how it's done.
Okay. Thank you, officer.
Thank you.
So just on that same point, just point of clarity. So when you had the NPAA, the union attorney was not with you?
That's correct, sir.
And how much time is it between the NPAA and the NFAA, you received the NFAA, how much time is that?
I would say 30 minutes.
And so during that 30 minutes, the union attorney was there sitting next to you.
That's correct.
Okay, okay, thank you.
Thank you, sir.
Okay, are we ready for closing statements?
So, yeah, so
sorry.
the city has 6 minutes, the appellant has 3 minutes.
Okay.
Please try to stay within that. We know it's important, but please try to stay within that because you see we're 30 minutes beyond our regular time anyway. If we had another case, we would have to stop, but we don't have a case right now. But please stay within those times. Thank you.
Ms. Hardy, would you please make your closing statement?
And Mr. Chair, we'd like to allow the appellant to go first, please.
Mr. Hawkins, I object to that. That is not the way this hearing is supposed to be run. The city is supposed to go first. They have
Yes, you're correct, Mr. LoRusso. Ms. Hardy, your closing statement, please.
Absolutely. Thank you, Mr. Chair. Chief Shields had the authority to terminate and did so to protect the city and the Atlanta Police Department officers. As an APD officer, Mr. Gardner was to adhere to the Atlanta Police Department work rules, specifically 4.2.5.0, prohibiting the use of unnecessary or unreasonable force, and he did not do so. Like Mr. Gardner, all APD officers may be dismissed for violating this rule. Chief Shields was the appointing authority and the only person with discretion to terminate Mr. Gardner. As we heard today, Chief Shields watched at length videos of Mr. Gardner's conduct towards Ms. Pilgrim. She watched the videos you have seen today, which, as we know, was only a small snippet in the time allowed, and watched them multiple times for multiple hours. And you watched them too. You know that there was no discussion of a gun before Ms. Pilgrim experienced having a taser deployed at her. Mr. Gardner's body cam footage shows Gardner run in past other officers and immediately tase Ms. Pilgrim. We don't hear her say no. She is asking what is going on. We ask that this board give appropriate weight to what Officer Gardner has described today, which does not appear in any of the video footage. Chief Shields appropriately determined that appellant's conduct violated the APD work rule. And indeed, his conduct was entirely contrary to his duty to serve and protect. He used unnecessary, unreasonable force under the circumstances. And despite growing unrest owing exclusively to the public impressions of police brutality, the chief was the decision maker and made the decision to dismiss Mr. Gardner. But even if the board disagrees with the chief, there were other grounds to uphold Mr. Gardner's dismissal, including, at a minimum, the untruthfulness in his incident report, as was clearly established on the record today. And to that end, even if this board elects not to affirm his dismissal, which we believe it should, Mr. Gardner clearly is not entitled to back pay. Again, Chief Shields was the one who had the courage to take swift action and do what was necessary to protect our city. She had to keep peace in a city plagued by very real public fear of police action. She acted with courage in taking action against conduct harmful to public perception of the APD. She kept the protest climate from becoming more dangerous to the city as a whole and to her officers specifically. Given statutory and case law authority, it is Chief Shields' judgment that matters today. And if the board reverses the chief's termination of officers, that would be the board replacing the chief's expertise, experience, and responsibility in this circumstance. This action was quick, but it was also in compliance with the city code. As you heard, Chief Shields moved quickly given the emergent circumstances. She told us that the city was a powder keg, but she also acted in compliance with the Atlanta City Code and the cold controls, as Georgia law confirms. We again refer the board to the Hammerhand case submitted here as City 21. Mr. LoRusso focuses on other code sections, such as Section 532, yet the first sentence of Section 532A states its conditions for use for suspending an employee. Excuse me. Consistent with 526, Section 530 explains how to carry out an immediate termination. Appellant seeks to make Section 532 relevant. It simply is not for this case. Neither Sections 526 nor 530A reference Section 532. It's just not at issue in this case. Similarly, Mr. LoRusso focused on APD SOPs for standard discipline matters, where APS will conduct investigations in appropriate cases. And we talked a lot about how the SOPs identify priority 1 offenses, for example. It makes sense to have detailed standard operating procedures for normal situations, but this wasn't a normal situation. It was an emergency. The SOPs don't control and are merely noise in this situation. And the SOPs fail to explain how the city code requires any more than what is set forth in sections 526 and 530. Mr. Gardner received his due process. He received notice in compliance with the code and an opportunity to respond. The code does not require an OPS investigation or statement before termination. And the code does not require the chief to wait for a union rep or attorney before terminating an employee. And now, of course, Mr. Gardner is receiving Civil Service Board review, another important part of the due process to which he is entitled. Because Mr. Gardner's APD dismissal is supported procedurally and substantively by the Atlanta City Code, the city asks that this board deny Appellant Gardner's appeal and affirm his dismissal from the APD. We thank you for your time today.
Mr. LoRusso?
I want to thank you for taking the time to listen to this, because this has been a lot to take in. This is interesting because we have officers that can be fired for violating policies, but the policies don't matter. We have officers that can be fired for violating policies, but the chief doesn't have to follow them. And the city wants you to believe that someone gave a personal response versus someone didn't give a personal response. That doesn't really matter, but you can check that they gave a personal response when they didn't. The chief's recollection, I'll give her the benefit of the doubt because she's now a sitting police chief someplace else because she's been replaced. But when you look at the situation from the perspective of her version of these events and Investigator Gardner's version of the events, why didn't she just say that he had his union attorney there, but it was an emergency? She didn't say that because they didn't follow the procedure in the ordinances for an emergency. It doesn't say suspension in 532 or 530. It says removal. And you've heard from 3 people now that a person can be removed and then an investigation can be done. We heard so much about emergencies. We've heard about tremendous emergencies. Well, we all know now what the emergency was. They had to be fired before the press conference came up. Nothing prevented for the city from saying, these people will never walk the streets of the city of Atlanta until this investigation's done. Same effect. We're taking this seriously. We're going to investigate this. And you may not like the use of force. But when he went to work that day, and as he said he was going back to work the next day, he had a reliance on these policies and these ordinances. And he had a reliance that he would get due process. And he had a reliance further that all 3 of you would listen and call the city on their maltreatment of this officer. And if you want to see an act of desperation, well, yeah, we shouldn't have fired him for this, but we had plenty of other stuff to fire him for. There's a blatant lack of due process. You know, when we sit there and look at this situation and how these were college students, well, the mayor told her son not to go downtown during these riots. And it's going to take a lot of courage for y'all to do the right thing. in Georgia, not too far from the city where they were patrolling, there's a saying on the Supreme Court. It says, fiat justitia ruit caelum. It means let justice be done, though the heavens may fall. And when Mark Gardner went to work that night, it looked like the heavens were falling around him. But he went to work while everyone else was in their bed and staying out of the city. And for that, he deserves everyone's respect, and he deserves a fair shot. He deserves to be put back to work, given back pay, given all of his rights back. And then if the city wants to do an investigation, they can do so. He's earned that in 23 years of service.
Okay. Thank you, Ms. Hardy. Thank you, Mr. LoRusso. The hearing is now over. We will issue a report in roughly 20 to 30 days with a final decision. Thank you and enjoy the rest of your day.
Thank you.
Thank you. Bye.
Thank you, board.